request the participants to kindly keep the mobile phones on silent mode for the smooth conduction of the program. Thank you. Comparative methodology is a way of studying the laws of different countries. It includes various processes such as analyzing the laws and comparing them on a different basis. It emphasizes on the legal mechanisms being adopted by countries and compares them. Today, we all have gathered here to gain some wisdom on the topic of today's workshop, teaching environment law, comparative methodology. Without taking further time, I invite Dr. Manoj Kumar B. Hiramat, IQAC Coordinator, KLE Law College, to kindly deliver the welcome address.
Good morning, all. Respected dignitaries, honorees, invitees, dear students. Teaching Environmental Law, Comparative Methodology, a workshop in association with the Center for Environmental Law Education, Research and Advocacy of National Law University, Bangalore, India University, Bangalore. So today we have assembled here to undergo the workshop to understand how to teach environment law in a comparative method. To address us, we have two dignitaries with us. I extend a warm welcome to the chief guest of the event, Mr. K.W. Ankur, Professor, Cologne University, Germany. I extend you warm welcome, sir. And today we have with us Professor Dr. M.K. Ramesh, former professor. And extend a warm welcome to our principal, Dr. J. Mallikarjuna, sir. Welcome, sir. Also extend a welcome to our vice principal, Dr. Anita M.J. I acknowledge the presence of the faculty members of other law colleges of Bangalore, Arnodia Law College, Panchami Law College, Vivekananda Law College, Bangalore Law College, and the students of PG department from University Law College, Bengaluru, and all PG students of KLE Society's Law College and final year students of KLE Society's Law College. I extend a warm welcome to all of you. I extend a warm welcome to the members of CEERA and other invitees. Thank you.
Thank you, sir. Now I request Mr. Kavi Shankar, Assistant Professor, KLE Law College, to kindly introduce our guest for today's session.
Thank you, ma'am. Good morning, everyone. Good morning, everyone on the dais, off the dais. So the guests for today are Professor Dr. Kirk W. Ankur. Sir has a rich and varied experience in US American law, international environmental law, European Union law, law and science, and law and rhetoric. Sir received his BA from Penn State University, his Juris Doctor from Duquesne University School of Law, and his PhD from the University of Pittsburgh. So was a postdoctoral fellow at the University of Bonn and at the Ministry of Justice in North Rhine-Westphalia, and completed additional studies in German law at the University of Tübingen. After completing his legal studies, Professor Ankur worked as a research assistant to James E. Rowley, President of the Pennsylvania Superior Court. Professor Ankur was Environmental Litigation Counsel for 10 years, representing the Pennsylvania Department of Environmental Protection in local, state, and federal US courts. Professor Ankur taught part-time at Geneva College in Beaver Falls, Duff's Business Institute, and the Community College of Allegheny County, Pittsburgh, before becoming a full-time member of the Mathematics and Science faculty at the Open University in the United Kingdom. Sir then held the first cross-border academic post in Ireland, serving simultaneously as a full-time member of Queen's University in Belfast, Northern Ireland, and Dublin City University in Ireland. Professor Ankur was an associate professor at Duquesne University School of Law, where he was also the director of International Studies program and taught the law of professional responsibility, civil procedure, public international law, international and environmental law, comparative law, European Union law, and international business law. Currently, Professor Anka holds the chair of US Law at the University of Cologne. Professor Anka has also served as a member of the Selection Committee of the Arts and Humanities Research Board in Bristol, UK, as a referee for the Institute of Physics, London, as a project advisor to the European Commission on the research project titled Child Abuse on the Internet. And Professor Anka was a founding member of both the European Network for Science Communication Teachers, ENSCOT, and the European Network for Science Communication Researchers, ENSCOT. Sir is a co-editor of the treatise on comparative environmental law and regulation, published by Thomson Reuters. And Sir is also co-editor of Environmental Policy and Law, published by iOS Press, Delhi, as well as the Journal of Health, Environmental and Educational Online. Sir has received research grants from European Commission, the German Federal Ministry of Education and Research, the Royal Irish Academy, the German Centre for Research and Innovation, and the British Council, fellowships from the University of Pittsburgh and German Academic Exchange Service DAR, and funding support from Santander Bank. We welcome you, sir. Our guest of honor is Dr. Professor M.K. Ramesh, former Professor of Law and Chair Professor, Urban Poor in the Law by Ministry of Housing and Urban Poverty Alleviation, Government of India. So, did his education from in bachelor, masters, and PhD level from the University of Mysore. Sir has been a professor at the National Law School of India University since June 1992 and has served as the University Vice Chancellor from August 1, 2019 to September 25, 2019. Sir has a rich teaching experience of over 40 years and has worked for over 2 years as a commercial tax officer in the government of Karnataka. His areas of specialization include international law, human rights law, environmental law, and natural resource management law. Sir has founded 3 centers of excellence at the NLSIU. Those are Center for Environmental Law Education, Research and Advocacy, CEERA, our partner for today's seminar. Common Cell in 2009, Environmental Law Clinic in 2012. Sir has been a senior Fulbright Fellow in the US in 2005 and 6, and an Environmental Law Fellow in 2006 at Environmental Law Institute, Washington, D.C. Sir is the founder editor of the Indian Journal of Environmental Law, IJEL, and has published over 60 research articles and 5 books. Sir's teaching experience is vast. He has been an adjunct professor at IIT Kharagpur, a visiting professor at KTH Stockholm, a visiting professor at Law School Zurich, Dalhousie Law School Canada, Law School Warwick, UK, and has been associated with teaching the course on environmental justice at Pace Law School, White Plains, New York, United States. Sir has held the positions of Chair Professor, Urban Poor and the Law, instituted by the Ministry of Housing and Urban Poverty Alleviation by Government of India in 2011 and 2016. Sir has been the chairman. Sir asked me to go slow on it, but I think it is absolutely necessary for us to not dispense with it because a rich resource person needs a befitting introduction.
My friends.
Sir, for the new friends like us. Sir, I'll quickly go through it. Sir has been a law expert member at the National Biodiversity Authority, a member of the steering committee for the 12th five-year plan on environmental, forest, wildlife, and climate change, an expert group member in reviewing the draft guidelines for the development of national legislation on liability response action and compensation for damage caused by activity dangerous to environment. Sir has been an institutional representative member for India at International Environmental Law Academy, Ottawa, Canada. Sir has been a member of Human Ethics Committee at IISc, member of Research Ethics Committee at IISc, expert law advisor to Legislative House Committee on Lake Encroachment at the Government of Karnataka, a law expert member at Task Group on Evolving Comprehensive Water Policy for Karnataka, a member of Law Expert Committee advising Madhya Pradesh State Biodiversity Board, member expert committee for reforming biodiversity law, NBA, environmental law fellow at Environmental Law Institute, Washington, D.C., on the board of directors, Center for Sustainable Development, Bengaluru, a life member at IESC, Bengaluru, and has visited US under the International Visitors Program and UK under the Faculty Exchange Program. Sir has been a part of research activities in a number of expert bodies on environmental law and governance, on environmental lawmaking processes, in biodiversity, water management, etc. He has advised Government of India and assisted its preparations for the Paris Agreement on Climate Change in 2014-15. Sir's contributions have been utilized by United Nations bodies such as UNDP, UNEP, Asian Development Bank, World Bank, IUCN, voluntary research groups, etc. on waste management law, biodiversity law, human rights law, environmental law, public service law, and legal education. Sir has developed a manual on hazardous waste management law in India for Environment Law Institute, Washington, DC. Thank you, sir. We welcome you.
Thank you, sir. Now I request all the honorable guests to kindly inaugurate the session by watching the sapling. Thank you all. I will now request Dr. Ankar to kindly deliver the inaugural address.
Good morning, everyone. I had prepared some PowerPoint slides, but I don't think we need to use them. Show them.
You can use them right now after the second session, as you wish.
We'll wait for the technical section.
Let's do that right now.
Okay.
I'm totally happy because I'm able to listen to you again after. That's why I connected with you. ನನಗೆ ಸ್ವಲ್ಪ ನಿಮಿತ್ತ ಮಾತ್ರ ಕೊಲ್ಲಿಗೆ ಅಂತ ಬಟ್ ರಿಯಲ್ ರಿಲೇಶನ್ಶಿಪ್ ಟೀಚರ್ಸ್ ಮನೆ ಕುಟುಂಬ ಓಕೆ ಸೈಲೆನ್ಸ್ ಹುಡುಗರು ಹೇಳಿರ್ಬೇಕು ಹೇಳ್ಬೇಡ almost from last 2 months that is sort of follow up folder.
Okay. Okay, good morning once again. The title that I've given to my presentation here regarding teaching environmental law is teaching with more inspiration and with less information. Thanks very much for the introduction that was given to me earlier today. One of the things that was not in that biography, I believe, is that for 10 years I was a state environmental prosecutor. And part of teaching environmental law to me is having had the experience of having practiced environmental law. And so before I began teaching, which I've now been doing for 33 years in all of the places that our colleague listed to you earlier. I was a state prosecutor. And what one sees over time with these, in these more than 30 years, I think Professor Ramesh will attest to this as well, is not only how teaching environmental law has changed, how the university has changed, how our society has changed. And the university as an institution has to change with it. And insofar it has to change with it, this is the outline, and maybe for the inaugural here today, the keynote, to get us started on our discussion, I might not say much more than what I have in the outline here. The first point I put here, although it should have been in the other order possibly, is a focus on litigation rather than legislation. For this audience, and I was talking to the colleagues earlier, I'm originally trained in US law before working in Germany. And I have to tell you that after working in Germany for 13 years, the civil legal way of thinking, what continental Europe and 2/3 of the world thinks is the legal way of thinking, still remains strange to me. So I feel very at home being in India among common law colleagues, because the way we think about the law in ways that are new to me every day, that I think is normal, and then I realize when I speak with an Italian colleague or a French colleague or a German colleague, they have a very different way of thinking about the law. There's this sort of standard thing when you ask a law student, what's the difference between common law and civil law? And this standard answer comes out regarding sources of law. The common law relies upon judicial decisions, and the civil law upon codes of text, codes of legislation. That is possibly true only for the sources of law. But that is already a bias to suggest that the sources of law are the focus. If the focus is the practice of law, not the sources of law, then we see all sorts of differences that are far beyond simply what texts we rely on as our sources. And that, to me, goes back to the point here in the outline that we need to focus more on litigation and less on legislation. I regard this as a push and a pull, which I'll mention in a moment, and I don't want to overrun my time here, and I'm looking at the clock right there I can use. Okay. I regard it as a push and a pull for the following reason. Legislation, as I said, the society changes. We're in an era of populism right now. In an era of populism worldwide with many governments of the world, what we see in the legislative process is an influence that we have never seen before, both upon the legislative process from lobbying and after the legislative process during implementation through advertising and media. So the sort of story that we would tell ourselves, that we would tell our students, our pupils, that the legislative process is you vote for the legislator, and then he or she gets into the legislative body and passes the environmental legislation that will correct the problems, and then we implement the legislation. This is a bit naive. And if we put into this circle of how this works, the fact that there is more money spent on lobbying than there is on the legislation itself, I call that the push to take us away from focusing on legislation. The pull to get us to focus on litigation is the fact that I think in most countries in the world, certainly in this country, there is still a respect for judges and a quickness about getting to the court, certainly to getting to the NGT, with the guarantee that the NGT provides, that you will get something that is not mediated by lobbying, that is not going to be mediated by social media and advertising, but you're going to get a lawyer, not a politician, to whom one takes the problem and gets a resolution rather quickly. And there have been around the world, and I can show you cases from all over the world, where litigation is growing tremendously in the simple area of climate change, for instance. And we take actions now against our own states, for having failed to take legislative action that should have been done to prevent climate change. We take actions against other states. We can take actions against those who we claim to have caused it. We take actions based upon human rights now. Professor Romesh is an expert in human rights. We know that in human rights that the United Nations just last July claims that the environment is a human right. And so this is where we see the bases for litigation having effect. Perfect example from my own Germany is that 2 years ago, when the federal climate statute was passed, there was no budget put into it past 2030 for carbon. A young woman, very much like Greta Thunberg in Germany, who would be unknown outside of Germany, together with a small NGO, filed a lawsuit against the federal government. And she filed a lawsuit against the federal government, claiming that without a carbon budget until 2030, there was no future carbon budget. 2030 is very soon. And just like with Greta Thunberg, or like the Urgenda Foundation in the Netherlands in 2018, this lawsuit was regarded as being cute, naive, something that a nice young woman would do, and she'll get her picture in the paper, and people can say, isn't that nice that young people are active? But it's not going to have legal traction. The Urgenda Foundation in the Netherlands in 2018, it was the same idea. It was a group of citizens, 288 citizens got together for this, and they filed a lawsuit against the Netherlands, and at trial, they won. And so the Dutch state appealed, and everybody assumed, of course, they will win on appeal. On appeal, the Dutch state lost again, so they appealed to the Dutch Supreme Court, and at the Dutch Supreme Court, the Urgenda Foundation won once again. That the Dutch Supreme Court ruled that the Dutch state had failed to take the action it needs to take under the Paris Agreement to guarantee climate action for its citizens. Well, this woman in Germany did the same thing, and she also won before the Federal Constitutional Court of Germany. The Federal Constitutional Court of Germany ordered the parliament to change the federal statute. That, to me, shows that the litigation had to be used to correct the legislative failure that occurred before that. That's all I'll say on litigation, on legislation. More inspiration, less information. The era in which we live right now with the internet and social media has provided us all with a shock about how it is that we know. Simply, how do we know things? The things that we had trusted for a long time. So I was just given this earlier today is a perfect example. We in academics for a long time rely on the peer review system. The peer review system will guarantee to us that when colleagues say that this is acceptable information, that it is acceptable information. And even unconsciously, if you get a book from the library, it has gone through a publishing house. If the publishing house is worth anything, it also uses some form of editorial vetting or a peer review process. The internet generally has no such guarantee to it. I'll be interested during our discussion later today and from the colleagues today, but in my experience, students don't see this difference. I'm old enough to have been teaching before there was the internet, and when the internet began, I was teaching an ethics course, a legal ethics course in the United States. The student answered a question, and I said, okay, what is the source of information for your answer? And her answer was the internet. Because the internet is not a source. The internet is a tool by which you access sources. What was the source that you accessed through the internet? That was not a concept to her. If she did the word search and got an answer out of her laptop, that was a source to her. So this is, for the younger people in the room, of course, this is obvious. This is how you get all your information. But we have to have a way in which to say that information is valid, is acceptable, is agreed upon. And we're struggling with that. I don't think that is as settled. It is the most unsettled that we have been at any time in history as to how we accept what we believe to be true. And for that reason, we have people who continue to believe there is not climate change, or that climate change is not anthropocentric, that COVID was some sort of government hoax. These things are very easy to perpetrate now. So what do we do as teachers? This is why I say more inspiration, less information. The information, true information, the information that we would want to teach as teachers is available on the internet as well. The job is to be able to teach judgment, to get the acceptable information and distinguish it from the non-acceptable information. But in addition to that, there is something that we need to be doing at the university that we didn't do in the history of the university. We're not here to inform any longer. There's more in every laptop in this room than I will do in my entire career. Being simply a source of facts is no longer what the information or what the university's role can be. So there needs to be some other role, or else we're out of business, I suppose. And the other role, however, can be to teach this judgment that is necessary, that we took for granted in the past because we got all information from peer-reviewed journals. But it's also to inspire. And I think this is a challenge for us as law teachers in the current disinformation age, is to inspire the students to be able to find the information that is accurate, is acceptable, is valid, and not go into the echo chamber that social media would put him or her into. The third point of my outline there is, because we're talking about comparative method today, I was pushed into comparative law by working in Germany, as I said to you earlier, and working with civil lawyers who really are from a different planet. When I work with them, the things that they say sometimes, for instance, we were just talking this morning, environmental law in Germany is a subcategory of administrative law. That's it. And that already, I've seen some heads do this in the room. That's how my head turns as well whenever a German lawyer tells me that environmental law is a subcategory of administrative law. But that's their way of thinking. And one of the things that we learn in comparative education is respect for other cultures. And other cultures understand law and legal systems differently. It has to be respected as such. So I came to comparative law not by choice, but because I was forced to. I was forced to check all of my own assumptions about how law works, realizing that I was only thinking how common law works. Because until Germany, I had worked in the United Kingdom, the United States, and the Republic of Ireland. They're all common law states. And even though I thought I had already been doing comparative law, I was doing it within a narrow bandwidth. They were all just common law states. And when I hit this juggernaut of working with civil lawyers, I saw how different that was. So what I find is when I teach German law students that our perspective, our common law perspective, they find it equally as foreign, as different in the way in which they think about law as we might find their way of thinking about law. But it's not just about that if they are then coming to India to be a lawyer, or if they're going to the United States to be a lawyer. It makes them better lawyers if they never leave home. And this is an important part of teaching environmental law. I think that comparative environmental law is an essential part of simply teaching environmental law. The phrase that I like to point out with that is all of us environmental law teachers are guilty of the following. We all talk about the law, no matter where we are in the world. We could be in South Africa, Canada, or Korea, and when we talk about what we're teaching, we talk about the law. What we mean is the South African law, the Canadian law, the Korean law. When we say the law, we're almost allowing the student to believe it's the same for everybody. And of course, that is not the case. When we do comparative law, and this is the fourth part of my outline here, and this connects back with point number one, I find that legal culture not the text of statutes, is the thing that is most insightful and enlightening for the student to study. Legal practice is part of legal culture. Again, and I by no means mean to disrespect my German colleagues here, but they are the real examples that I can use among my family here of common law lawyers as being the other when I talk about my German colleagues. The German sense of comparative law is to compare statutes. And when I say to them, I say, well, how do you know how that statute is actually used in practice? And if you don't know how it's used in practice, then what is the point of studying the statute? When I teach comparative law back in Cologne, I fortunately do have students from many different parts of the world in the room. And without failure, every semester, after about the fifth week, 2 or 3 of the African students will come to me after a lecture. And they come up next to the podium, and they don't want to say it in the open room, but they come up to me afterward. They say, Professor, we've been listening to all you've been saying the first couple of weeks about constitutions and statutes and regulations. We have all these things too, but it's not implemented. And that, to me, is exactly the point of why you don't study text if you want to study comparative law. You don't study the dead law on paper. It's difficult to study law in practice. How does one do that? This is part of the question today about method. Immersion. I have the privilege of being with you today. I get to travel to India to look to see how law is practiced. So 2 weeks ago, I was in Delhi, and I made sure that I made a point of going to the High Court and going to the NGT to observe. That's the laboratory for the practice of law. This is how you see law in action, law being practiced, not studying text on a page.
Yeah.
Some examples that I can give you, when I was in Germany, a colleague from the United States, a federal judge, came as a guest lecturer for a semester, and his wife went to Africa, sub-Saharan Africa, to do some work during the same semester. She rejoined him in Cologne before they went back to the United States. I asked her how her time had been, and she said it was okay. I said, only okay? She said, yes. And I was teasing her. I said, didn't you tell your host that you're the wife of a famous federal judge from the United States? She said, yes, and that's when it went bad. I said, what do you mean? She said, well, what I didn't realize is in the country in which I was working, judges are the most corrupt people in the society. That's legal culture. And if you don't know that, reading a statute on a page is not going to tell you how the legal system works there. Another example I have in Germany, I've been asked to be expert witness a number of times before courts in Germany on U.S. law, if U.S. law has been pleaded in a German case. And in one case, I was asked to give an expert report on tax law, in which I am no expert. It was a simple matter of federalism. And the tax court asked me, they said, well, on this question of the spin-off company, what is the answer? I said, well, I studied the court opinions on this in the United States, and the majority of opinions would say this. And the judges looked at me. The judge said, we don't want to know what the judge's majority said. We want to know what is the answer. And I said the same thing again. This went on for about half an hour. And at first, they thought I was just being difficult, and I thought they were just being difficult. And what slowly began to come to my mind was the role of the expert opinion in Germany is different than the role of the expert opinion in adversarial litigation. It's not adversarial litigation. They think the role of the expert is to be the one right answer, and that I should have been giving them the one right answer, which they would then just adopt. And it took us quite a while before, as I said, half an hour before we realized we have a different concept of what an expert is in two different legal cultures. Also, once we're working in Africa and Ethiopia, I was talking to a colleague who's a constitutional law teacher in Mekelle, which fortunately is now with electricity again and no longer at war. And I was asking him about land rights in Ethiopia because he was working in environmental law. And he started to answer, and he paused and he said, I think I should tell you first, Kirk, but that he said in Africa. I think what he really meant to say is in Ethiopia. I don't think he can claim to speak for all of Africa. But he said, I think I should tell you first, Kirk, that land rights here for us, the state and the state courts are alien. I said, what do you mean? How do you settle land right disputes if the state and state courts are alien to you? And he said, we settle them under a tree. The people of the village go to the elder, and we settle under the tree. I said, well, then I asked the question that we should ask in comparative law, why? Why is there that difference? Why don't we use the state courts? He said, to us, state courts on those matters are still European inventions that were pushed upon us during colonialism. And we still don't accept them. So as a cultural practice, they are there. And if you were comfortably sitting back in Cologne and you want to study land law of Ethiopia, you would see that there are statutes on land law and their courts have jurisdiction over this. He said, nobody goes there for that. So these are just some examples that I give you on why, looking at number 4 in my outline, legal culture, not statutory text, must be the focus of what we do when we attempt to study law in action, law in practice in another culture, rather than looking at the dead text on the page. And finally, the number 5 there probably doesn't deserve to be its own. It's more of a note to myself. But we have this sense sometimes. I was just telling colleagues at breakfast this morning, I spend more time with the natural science faculty than I think I do with my law faculty. And when I work with the natural science faculty, of course, they like to see the world as being dictated by the limits and opportunities of the material world. Insofar as that's the case, what we find, however, is more information about the so-called objective information in the natural world isn't changing people's opinion. We have been pushing and pushing and pushing to get more information about climate change. How many conferences of the parties now? Every November? This is getting to be a joke. 28 years? Really? We think that we're we call it taking action after 28 years? There's enough information out there. We don't need more information. So what I try to work with insofar as we have to work with the natural sciences in environmental law, I try to point out to the natural science colleagues that the natural sciences, insofar as they provide this information, don't expect that alone, as given to the public, is going to just change things in that regard. And this is why law is necessary. Creating norms for normative behavior, for guiding behavior, for limiting behavior isn't simply about providing information. So I just use the outline then to get us started today for the opening then. Thank you very much for your attention. And we'll go into detail on this as we see fit as the day progresses. Thank you very much.
Thank you so much, sir, for sharing the insights on the topic in such a brief time. So now I would like to request our today's guest of honor, Dr. M.K. Ramesh, sir, to kindly address the gathering.
Our guest, the real guest, the guest of honor, Dr. Kirk Uka, the Dean of Faculty of Law of the KLE Law University, Professor Manikantanaya, my friends from CEERA, my colleagues like Girish. I think I've seen every one of you, most of you have known you for decades, so I'm at home. And if I speak in the commonest language as we are used to, I think Professor Kirk would excuse me. And I just have 5 minutes within which I needed to just put things together to take you to the next session. And that's all what I require because after listening to Professor Kirk Unker, who really put everything in context, I have very little to convey to you. But I think I'll be uh, failing in my duty if I don't start with one observation of a lack. We miss the real player in this entire exercise of bringing all of us together. Professor Sairam Bhatt, it appears he is unwell and unable to make it. And along with Professor Mallikarjunaya, he had planned this entire event in a very elaborate way. And we met just 5 minutes before the commencement of the sessions, and we had to do a little bit of a doubling up as to how do we really plan this or rework the entire exercise. And it was agreed that, as approved by Professor Mallikarjunaya, this is how we go about the entire task of these 3 hours now. You had the keynote, and that actually sets the tone, tenor, and even the dimension of the interactive sessions that are to follow now. And just have a look at some of the points made by Professor Kirk Unger. He starts with more inspiration and less information. It has been a little over 44 years since I started my career as a teacher of environment, as a teacher of law. And for the last 32 years, I think, I have been into teaching of environmental law. My gut feeling is in no way different from what Professor Unger has said. The second observation, legal culture, not statutory text, is the most important aspect of comparison. And the third, in environmental law, the objective properties of the material world are alone unconvincing information. And he, in pure cricketing terms, he sent a googly. Cricket is a religion in India. And we have a test match with Australia now, we share that. And your observation, very amazing. And this is what I did feel when I did a bit of a comparison of the common law traditions with the civil law traditions. But by and large, in the entire European Union, and Germany being the leader, environmental law in Germany is a subset of administrative law. And let me submit to you, what is environmental law in India? Environmental law in India is a Cinderella law. It's a Cinderella law, as you know, the folk tale. Not owned by anyone. Everyone speaks about it. Every policymaker, lawmaker makes it a point to mention about environment, the concern for conservation, protection, so on and so forth. And it is supposed to have been internalized in every aspect of our lives, but left alone. And that's what environmental law is about in the Indian context, with a little learning of it in the last 32 years has been my experience. But then, we are into pedagogy here. Pedagogy of environmental law, if it is left alone for you, and if it is not anybody's business, then why are we getting so much agitated about it? the environmental condition and how to really improve it through this instrumentality of law. And how do we really take our students into confidence in making them realize that this is something which is one of the most important components of their law learning. And that's where we get into this pedagogy. And being hopelessly and dangerously optimistic that I have been as a teacher, I must say that even after 32 years, just like you, it's more emotional, it's more inspirational. I find environmental law is something which is the most special, unique body of law which no other law can offer, both in terms of opportunities and in terms of challenges for definitely a teacher and a researcher in law. And I think this is something that we need to really put it across to our students, that this is something very unique, very special. When you think of and really deal with environmental law, I feel that you're dealing with everything. It permeates into every understanding of law, of those very compartments that you have: administrative law, constitutional law, criminal law, contract law, tort law, so on and so forth. This is one which is a common thread to every one of them. I think the first thing that we needed to do as teachers and research in environmental law is to bring in that connection and strengthen that bond, and not to be considered as a subset of any aspect of law, but something which informs, guides, and influences a very conceptualization and working of every other discipline within law. I just would like to take a little time in the next session, because thanks to Professor CEERA, but both myself and Professor Kirk have a little more time as to how well you can teach environmental law as an integral aspect of, and without which the learning of a particular area of law is useless. I never attempted that. Let me try this today. And you will be my laboratory to get into that kind of an exercise, that environmental law is contract law. I will do that in the next section. It just came to my mind, so I thought that let me just submit myself to that kind of an experimentation. Let me do that. But before doing that, let me just make another submission to you. And it's not just environmental law, every law that matters. And especially I hear about that in law research, that people talk about interdisciplinary study of law or multidisciplinary content in doing research in law. Let me make it very clear to you, and let's demystify law. That law, both in its definition and description, is not just interdisciplinary, is not just multidisciplinary, it is transdisciplinary. It transcends disciplines. In fact, law is not a discipline at all. It's a process, it's a tool, it's a device, and something which is a process, which is a mechanism, cannot be pigeonholed into any single discipline. And environmental law is one wonderful candidate to transcend every conceivable discipline on earth that you have. And so the experimentation that you do as a teacher in law, in environmental law, should be first to strengthen the bond between environmental law and other aspects of law, to engage your students, to bring in that kind of relevance to the learning of it, because he brought in his vast experience as a practitioner of law. And you go to the courts of law, and even in NGT, with all due respect and regard to the judges and the law practitioners there is very little of environmental law that's being brought into the whole scheme of things in the entire advocacy skills that are displayed there. It's either brought within the umbrella of some of the constitutional safeguards that you have using the vehicle of public interest litigation, or as something which is, as I rightly mentioned, as a subset of administrative rights, something to do about implementation. If environmental condition is bad in India, it's because of poor implementation. I think it's absolute nonsense that people speak of. It's about legal cultures. Please keep that in mind. When you are looking into any legal system as to how the health of environmental law is about, it's about the legal culture, or the expression that we use is the ecosystem, and which is a host of traditions, practices, some good, some bad, and quite a few ugly, and in which law is also there. That kind of a thing. My 5 minutes is over. Let me not get into a lecture here. But I think some of the strands that were put across by Professor Kirk, I think you should really find it interesting as you develop. Because in the whole scheme of things, as Professor Mallikarjuna mentioned, that we will elaborate a little bit of it in the next section. That's why I said that when I say transdisciplinary, I will only pick on that contracting. But there is scope for elaborating it further, and that's what you have to do. In the session after that, all the three of us would be mute spectators of listening to you, your experience of teaching environmental law, the issues that you would like to raise in the context of what Professor Kirkanga has brought together, and see how we take it to the next level of learning of environmental law as a pedagogical experience and something which is worthy of research, not of the kind that we have been doing all the while now, but something far more subliminal, something which is to be put to application both in law practice, in administrative practice, at the level of policy making and things like that. How the teachers and educators that we are could be the agents of such a kind of a transformation for a better environment than in which we are living in. Thank you.
Thank you, sir, for various interesting, beautiful observations. Now, I would request Dr. J.M. Mallikarjunaya, Principal, KLE Law College, to give presidential remarks.
Esteemed chief guest of today's program, Professor Anka, our beloved Professor Ramesh sir, uh, my dear colleagues, my dear student friends, Madam Ajila, the principal of Bangalore Law College, student delegates from University Law College, LLM students, and all other invitees, more importantly, esteemed members of the CEERA team. Of course, in the absence of my beloved friend, Professor Sairam, but with whose initiative this program is finding delighted to be today. Well, having shared the common passion for today's subject, namely environmental protection and environmental law, and Secondly, having been busy over 25 years in the business of education, last but not the least, having been the part of this program as a president of this beautiful occasion, I would like to share a few aspects on this occasion. I was trying to articulate the importance of this session in this program and wanted to call it a tone setting session. Whereas I had to learn few more aspects from Professor Ramesh, and now I would like to call it the TTD session. Tone, tenor, and I'm sorry, sir, you must be other word. Tone, tenor,
Dimension.
dimension. I'm sorry. Thank you very much. This session, yeah, this session, I wish should indeed be the tone, tenor, and dimension setup. Having said so much, I assume the responsibility of speaking about, especially it's not environmental law that we have come to learn here. We have come to learn how to teach environmental law. And a few words about teaching now. We must understand that teaching today is no more teaching, it is learning. Gone are the days when knowledge was transferred from a jug full of water to the glass which is empty. Gone are the days. Of course, I must say jug is full of water, but glass is not empty anymore. Hope you agree with that. Or at the click of the button, whole lot of information is available. That's where the teacher has got to make difference. And it is rightly so, we have got to make difference. So now there is a shift from teaching to learning. That is where almost 5 decades old, more than 5 decades old, learning methods that were invented in US called the Bloom's taxonomy of learning and assessment methods have come to occupy their field today, and they do so rightly according to. Else the teaching becomes irrelevant, the teacher becomes irrelevant unless the teacher holds the hands of students and make them learn by themselves. Teaching becomes irrelevant. Kindly bear with me for some time. On the day of environmental teaching methods, why am I talking about the teaching and teaching methods exclusively? I'm not trying to speak about it exclusively, and I'm going to bring connection to what I'm talking about. Almost half the population here is aware of Bloom's taxonomy, and few are unaware. Hence, I take this opportunity to speak a bit about the approach that has to be brought in stopping teaching and in starting or introducing learning. We do when you go across Bloom's taxonomy, essentially we witness three methods of learning. I'll try to touch as superficially as possible. The first one we call the cognitive learning. The second one we call the affective domain learning, and the last one being psychomotor. I'll try to explain them as much as possible. Acquiring of knowledge, its application, evaluating its utility, analyzing it, and creating the new knowledge. Kind of things fall under what we call as cognitive domain, which is related to knowledge by and large. Psychomotor domain would speak about how we apply the knowledge that we acquire. In other words, skill sets that we give in our teaching. Affective domain is more important. Not only that I learned things, not only that I equipped myself with application of what I learned. What I learned becomes, it is internalized for me. I value that. That becomes my part of personality. That is where the education gets it complete, is what I believe. Affective domain deals with attitudes, love for what I learn, making it part of my life, kind of things. With this, I come back to the importance of environment. I mean, environment education. environment education essentially is related to man and his relation with the environment. There cannot be a meaningful environment education. There cannot be a meaningful learning in environmental law unless the right attitudes are developed in the students. It is a mere but a pleasant coincidence that I had to see the very first slide from Anka's presentation that environmental law teaching means less information and more inspiration. What a fantastic line that sums up the importance of what activity we are going to take for. Though I am a greatest votary of textualism, I am a passionate believer in contextualism. In fact, those were the lines Professor was talking about, not the statute but the legal culture. And with this initial remarks, I wish you to think about environmental law teaching, not to make our students the jail's advocate, but to make our student a passionate lover of environment, so that the true ends of environmental laws will be fully met in the course of time. It is with this objective and with this approach I wish you to take your today's learning forward, because we expect each of you to be the meaningful environmental law teacher. And we already spoke what environmental law teaching means. So repeat, environmental law teaching doesn't mean giving a lot of information, it means introducing a lot of inspiration. I wish all of you to see the subject from this angle and be responsible for the success of today's program. And if I may, lastly, draw the analogy and the anecdote Professor Ramesh sir was presenting. It would be great if you take the responsibility of exposing Cinderella to the prince, and environment and environment protection, environmental laws, who have become the passionate subject of everybody, but not anyone who makes a meaningful job. I might cite some examples. Who doesn't love environment and environment protection like me? Everybody loves. How many of us put off the lights, put off the fans, put off the ACs, and go out after the job in the room is over? Great to know that. Few of you are there. How many of us put off our engine of our motor car when there is a red signal? How many of us plant the trees, though all of us always crib about chopping of trees for infrastructure development? I wish all of you think in these dimensions. Keep this at the back of your mind in understanding environmental law teaching. That alone would be the right thing to keep in mind as you go ahead and have a lot of learning experience. With these remarks, I must confess and tell you, though I believe what I spoke had a great purpose, there is another reason. Being no expert in the subject, I was unable to bring in any comparative methods of teaching, which will be taken forward in the next session by two professors who are experts in the field. But nevertheless, as a teacher for about 25 years, I felt it's my responsibility to share these views on the topic. Keep this in mind and have a greatest learning experience. Thank you. Thank you all.
Thank you so much, sir. I believe everyone here will agree with you that teaching, the definition of teaching has completely changed. And with the same, sorry, with the same view in mind, we have a technical session. I request Dr. Anka to kindly address the gathering.
Okay, thank you for the opportunity to speak again. What we're calling the technical session here would put into place then, if anything that I said in my outline is true, then the question becomes, how does one do this? And so let's have a look at how one does this. This is, I'll just go quickly through some of these points to develop them that I made earlier today. The push and the pull. This is why I say that legislation is overly influenced by lobbying and advertising after the fact. The Climate Accountability Institute report, just using, of course, climate is not all of environmental law, we have to keep that in mind. It seems to overshadow its thinking today, but the fossil fuel industry has doubled its contribution to global warming by emitting as much greenhouse gas in 28 years as in the first 237 years between 1988 backward in the birth of the Industrial Revolution. And yet it can be traced to just 25 corporate and state producers. We have to say state producers because, for instance, in Nigeria, where the largest industry is oil, the oil industry is 51% owned by the state. So oil production in Nigeria is state-owned. But what has been a response by these industries, if you look to the second bullet point here, what the fossil fuel industries have done in response to the problem is to spend more than 2.6 billion US dollars, or that equivalent, to control the narrative around climate change and not blame these actors, but to blame individuals. To reposition the idea that it's all of us who are the problem and not the fossil fuel producers, even though it can be demonstrated that just 100 carbon majors are responsible for 71% of the climate issue. And recently, talking about teaching and education, I have the opportunity to teach students in France as well in a program of commercial law. I'm not a fan of commercial law. You have to go to the dark side sometimes to see how things are going there, right? And when I talk with these students of commercial law about environmental law, all they want to talk about is ESG. They're going to save the world with ESG. So long as the corporations have social and environmental governance, some sort of program in place, that will fix the issue. The problem is with ESG, we find that most of the programs that are in place for that are only doing so because investors demand it. So since I went partially into the dark side, what I also do, this is the wonderful part about the age of online conferences that COVID has brought us. I can lurk on conferences all over the world as long as I can understand the languages. And I've been lurking on conferences from finance people. And finance people all over the world right now are absolutely excited and concerned and worried about the fact that they're financing projects that are not green. Not because they care about green, but because their investors say, we're not giving you the money unless you can give us back a project that is green. Is it green or is it just called green? That's the difference. That's why you don't get too excited about it. So what we find is global industrial greenhouse gas emissions are in fact backed by public investment, a fifth of them. So the investment issue as a way of going is not going to lead us there. This is that circle I was talking about. So in the black is the simple story we like to say. Citizens vote, politicians are elected, politicians make legislation, and the citizens are either happy or not happy, and then they don't vote for the same people or do vote for the same people. It ignores the two red ones, and I just gave you the statistics on that having been exposed as Exxon Oil has been exposed for having scientifically, believe it or not, in the 1950s, the late 1950s, Exxon already knew the concept of climate change and said that it would begin to have dramatic worldwide effects in 2030. Look how accurate they were. 70 years in advance, they knew that this was going to happen. They haven't done anything about it. What they've done instead is greenwashing and telling us it's not happening, not going to happen, and spending their billions on lobbying and spending billions on advertising after the fact. So we have to add those two things to the cycle of understanding how legislation actually does or doesn't address environmental issues. And finally, that's why I put litigate as the other thing citizens can do. They can give up on the vote. Because in my experience, very often, the environmental lawyer, the environmental law student, will come to me and say, I want to do something. This is what Fridays for Future is about. Young people being frustrated with the systems that are in place, as we said for the Conference of the Parties, for 27 years and no change occurs. That is insufficient. So they want to do something. In the past, we probably would have said, get involved in politics. Vote for the right party, vote for the right individual, get the legislation passed and so forth. I think that is as passé as what we've been saying about information equaling teaching before. And this is why I advocate that for the environmental lawyer focus on litigation. And citizens can litigate as well, citizen organizations. They can take action into their own hands and sidestep the idea that legislation is going to fix it. Okay, those are just statistics to support that. By comparison, this is just some in Asia, in Southeast Asia, this is just some of the recent successes of litigation in Laos, in Cambodia, the Philippines, Thailand, and also in Europe as well. I already mentioned in Germany and the Netherlands, and now we have extraterritorial litigation. 50 years ago, people in the Niger Delta lost their homes, their livelihood, because the oil industry there just destroyed the river. Flaring gas, all sorts of things. And they took a lawsuit, they won, was never executed upon. Because in Nigeria, oil is 51% owned by the state, and the state is not going to take an action against itself in that regard. Recently, the same citizens came back and they realized Royal Dutch Shell's corporate seat is in London. What if we take the action against Royal Dutch Shell in London instead and get a judgment against them in London? And they did. So this is how people are also using litigation to get around legislative problems like that. You mentioned all of this. Okay. Here is some information that I want to give you. We have at the University of Cologne every year for the past 15 years an annual conference on health, education, and the environment. What we try to do is work with a topic in an interdisciplinary way that includes law on how we approach these problems. And 2 years ago, our topic was why is there no action on climate change? Which people we'll talk about. And the experts from public health, from psychology, from science education, and from epidemiology, strangely, all came together at the conference without a plan in advance. They didn't talk to each other. And they arrived at a rather similar group of information about what they thought the information is. Knowing the facts of what happened, and there's the picture right there, isn't going to change anything. The United States, would need, if everybody lived the way the Americans do, we need 5 worlds. And the Americans know this, and it doesn't change anything. Okay? So that's, more information is not going to help there. That is referred to as cognitive dissonance. I know what the facts are, but I live contrary to what the facts are. It's more efficient for the day, it's more comfortable, it's easier, whatever the case is, but it doesn't comply with taking anything any further. And you'll be happy to see that India there is actually living under its weight. That India is at 0.7 worlds of use of the planet. When we talk about cognitive dissonance, knowing the facts of what happened, this is the reports for the IPCC. And the first one in 1992, the language used was, we are certain of the greenhouse gas effect. By the second one in 1995, it is unlikely that the changes are natural in origin. By the third one in 2001, human activities increased the atmospheric concentrations. So we've gone from, is it happening at all? Yes. Is it likely that it's natural? No. Now we know that it's us. And then by the fourth one, we get to sea level rise. By the fifth one, it's extremely likely to it's virtually certain. And then we get to the most recent one, and this is cognitive dissonance. In 2021, by report number 6, it is unequivocal. Human influence is very likely the main driver. Human influence very likely contributed. It is very likely. It is virtually certain. It is virtually certain. We don't need more information. You can't get more information. The science can't provide it. It doesn't exist more strongly than that. By the way, since we're lawyers in the room, I'm speaking on behalf of my colleagues, the natural scientists. Science doesn't produce certainty. It never has, it never will, it has never claimed to do so. Data is certain, science is not. And so this game that industry likes to play, until this language can say certainty, we're not doing anything, is denying understanding science. Science has never produced certainty, and it never will, and it doesn't promise to do so. Okay, so that's just that sort of thing. Let's go to how do we do something with education. Comparative law. Comparative law in practice relies on this old method from the Middle Ages about how we learn from the text. So we were just talking about text and context. This thing that in Latin was referred to as accessing the author, the accessus ad autoris. Ask these simple questions, which we as English speakers find to be easy because it's who, what, where, when, why, and how. Okay, so we get all these W words in there. I'm only going to talk about the why part at the beginning. Why compare? Because that's what we need to be convinced of in environmental education, and then how to compare. Why compare is in fact because we do it all the time. It's a natural phenomenon of the human being to be a comparativist. We're hardwired for it. Another reason is because it makes us better lawyers at home, whether we ever leave home or not, to see that there are other ways in which other cultures can approach environmental problems. And finally, for the practice of law, studying foreign law will give us opportunities for the client to show that there's more things out there. Because it is possible in 2023 that your client says, you know, I find the Indian law to not help me in this regard. I put my manufacturing in Bangladesh. And that has to be an option that can be made to the client. This is how we do have our natural ability to compare. We can just start with vision. We have the ability to have depth perception because of comparison. As we evolved and our eyes moved around the front of our head, we have stereoscopic vision. With stereoscopic vision, we have depth perception. That's a matter of comparison. That's a great advantage. It enabled us to move from being the prey to the predator. Okay? What we learn, however, from this, and it's not just metaphorical, is that this is occurring in the brain and not in the eyes. And this is how we came up with recognizing this. If you look at the bottom here, applied psychology does this work where they put eyeglasses on people that adds an extra frame, extra lens that turns the world upside down. Now you can imagine when they put those glasses on people, it gets people rather disoriented, makes them sick. They vomit for a few days, but they keep the glasses on because after 2 to 3 days, the person wearing those glasses begins to see the world right side up. What that tells us is it's the brain that sees, not the eye. The eye is just the instrument that admits the light. And the brain will interpret it. Interpretation is what counts, not the physical information that's coming in that regard. And then we take the glasses back off, and with no glasses on whatsoever, the person sees the world upside down. But after 2 or 3 days, the brain adjusts and sees the world right side up again. So what we realize is that comparison is something that we are hardwired to do. And insofar as we are hardwired to do, comparison is an interpretive act. This is an extremely important lesson then for comparative law and comparative environmental law. Let's skip that. Okay. So that's why compare. Let's go to how to compare. In comparative law, and I think, yes, okay, I'll just show you this one first. So we have, and it's just coincidental that these two gentlemen are German, who wrote this book, because it is considered worldwide a standard in comparative law. An introduction to comparative law by Konrad Zweig and Hein Kutz. They introduced this idea of functionalism. The idea of functionalism was to fix the problems that how comparative law had been done before then. When comparative law was first done in the modern era, that is in 1900. We all know about the Eiffel Tower. At the Paris Exposition in 1900, when the tower was built, it was not just an exposition about science and technology, it was also about social sciences, and law was there. And when law was present at the exposition, everybody came together from around the world. And it sounds outrageous for us in 2023, 123 years later. They actually thought they were going to build a one world legal system. Not a UN, not a place where people come together by agreement, but one size fits all for everyone. They thought that would be okay. Now, you can imagine what that one world system was going to look like. It wasn't going to look like Indian law. It was going to look like French law, of course, or German law, something in Europe. They thought it was making progress. So the goal of the Congress, according to Edouard Lambert, was a law that was common to all of humanity. That's what comparative law thought it was doing 123 years ago. That is no longer what we think we're doing with comparative law. So we've moved forward. We've gone through a number of ways to think about comparative law. Formalism was a problem. We thought we'd start comparing forms. We'll compare Indian Constitution to German Constitution. Problem? There's no document called the German Constitution. Because of the way the country was divided after the Second World War, there's only a document called the Basic Law. They didn't have a constitution because to the Germans, the country was not constituted after the Second World War. So if we only dealt with forms, we couldn't do that. Further problem, Constitutional Court of Germany with Constitutional Court of the United States. The United States doesn't have a constitutional court, so we couldn't make that comparison either. So formalism had obvious problems. Encyclopedism had problems, constructivism, these all had problems. We've arrived at this orthodoxy today of functionalism. So let's look at that for a moment of how to do functional environmental comparative law. Functionalism, according to Zweig and Kutz, says that, well, when you're looking at two systems, you lay out the essentials that have the same function. So for instance, what would you say the function is of having a green tribunal? Well, of course, it's to adjudicate matters. But what makes it different? Well, it has science members on the bench. That's a function of bringing science into the adjudicative process as well. That's different than simply having professional lawyers on the bench. Juxtapose the essentials, but then step 3 is the most important part. You ask why different systems need to function in different ways. Think back to the example I gave you earlier. Why did my colleague tell me that, well, in Ethiopia, when we settle land matters, we don't go to the courts? We settle land matters. The function is to settle a dispute about land. We don't go to the court. So we have to ask why if we want to understand the legal culture. The point that we've all agreed on this morning is what from understanding why different cultures solve the same function, the legal dispute or the dispute regarding land in my example, then you can build a system from that. Okay, I can give you some specific examples here. From the United States and Germany. Lessons from this step 3, why is there a difference? Why are they different? A breach of contract, or you can tell me this. Breach of contract, so Professor Ramesh has already introduced, we're going to talk about environmental law as contract now. What's the first remedy for breach of contract in India? Damages. Thank you, my common law family. This is for the United States as well. In Germany, it's specific performance of the contract. So the court will go to great lengths to try to force the contract to occur. Why is there a difference? Because the US, and I'm assuming India as well, does not treat the contract as a moral obligation. Germany does. And insofar as it's a moral obligation, the court's job is to enforce the fact that you made a promise and you should have to carry it out and not just replace the failed promise with money. So we have to ask the why question rather than just say, oh, come on, why can't we just pay the money instead of enforcing the contract? When you get an answer, if you ask the question, you have to ask the question, why is there a difference? Secondly, divisions in the law of obligations. The German Civil Code treats contracts and torts as combined obligations. So what one does as a German lawyer, as a German law student, is you ask the question, is there an obligation in private law between these two parties? And the first thing that you're going to look for is there a contract? Is there simply the most narrow and basic agreed upon? And if not, has there been an obligation posited on these parties by society? But this is sequential. These are two different areas. U.S. private law treats contracts and torts separately, as one does in India. Thank you, common law family. And if we ask the question, why is that, which I had to ask some years ago when I first started teaching torts in Germany, because the student asked me, why isn't this just part of the law of obligations? I had to do some research. Anybody know? Anybody want to volunteer? So the law of torts in the United Kingdom was criminal law at that time. And so since torts came out of criminal law, it was regarded as a separate area. At a wedding about 3 years ago in Greece, I sat next to a British barrister, and I asked him what line of work he was doing in the UK at the time. I was shocked at the answer. He prosecutes private crimes. Private crimes. I said, what are you talking about, private crimes? He said, yeah, it's still possible in the United Kingdom that you can prosecute crimes privately. I said, well, what happens to the person if you get a conviction? Do they go to prison? He said, yes. Well, what good does that do for you? Why would you bother to prosecute that? He said, it's rich people playing around to try to annoy other people. It's incredible, but it still exists. Why do I bring that story up? Because it shows us in the history of our common law that the idea of the tort, since it is actually a violation of a norm that is a societal norm, that was a criminal idea in English legal thinking. And so it only came into the law of obligations as a separate area next to contracts. The Germans think it's all the same thing. And if we don't ask that question why, we won't see that difference. Okay, there are problems, however. Functionalism doesn't save today. Functionalism is where we are now. Problems with functionalism are that there is the assumption that there always will be a common function. maybe there is not a common function between two legal cultures as to what is being carried out. And that is not built into the Twyre Court's model. So there are different options then to that. Alternatives that I can give you are translationalism and immersionism. I favor translationalism. Translationalism comes to us in two steps. One, we have to translate the language. People in India are always very good with this because I don't know any Indian who doesn't speak at least three languages. Because you have Hindi, usually Hindi, of course, Bengali is not necessarily the case, but you've got local language and then English. So people in India are very conscious of the fact that you move among languages and you have to make translations all the time, and it's not a one-to-one connect the dots. Languages are idiomatic and they only approximate other languages. People in other cultures are not quite that cognizant of how languages work in that regard. But when we do translation, we don't just translate the language. Let's say German to French. We have to translate the culture. You do this all the time with your client. The client doesn't know law. The client walks in. The client says, "This is my problem. Can you help me?" The client does not want to hear a quotation from the Forest Act. The client wants to hear in everyday speech how it is that you might help the client with the problem. You, as the practicing lawyer, must go through an active translation to do that. So we are doing translationalism to begin with, just to practice law with non-lawyer clients. It's necessary. So I would suggest it also needs to be done when we look to other solutions to environmental problems. A point that I like to make as well is that when people learn, and this is what translationism teaches us, you didn't first start learning law when you first started studying law. People grow up in a culture and they learn that you are to obey the traffic signals, that people must pay their income taxes, that if you have the obligation of a contract, you're supposed to honor the contract. These are things that you don't need to be a professional lawyer to understand about the legal system. And then you only get it polished by going to legal training and technical legal education. But look how it's different when you go to a foreign legal system. You're already a professionally trained lawyer in one system. And now you learn it as if, let's say, everybody today, let's think of a language that probably none of us speak, Swahili. And tomorrow we want to all begin to learn Swahili. Well, that's a very foreign language. What would we do? We would learn the rules of grammar, and then we would memorize vocabulary, add them to that. That's a very different way of learning a language than you learned your own language, right? That's also a very different way of learning a legal system than you learn your own legal system. Your own legal system, you begin by living in the legal system first, and then afterward, you have a professional study of it, after you've already begun to learn your own legal culture. When you go to a foreign legal system, you haven't learned the legal culture at all very often. This is the problem. Instead, you get representations of the other legal culture in school, in film, something like this. And then after you start to study your own legal system, then you study the foreign legal system in this very artificial way. Can we do better than that? No, we can't. We have to become conscious of the fact that when you do it that way, that's not the same way that you have done it to learn your own legal system. That's a very different way of learning the other legal system. We've used this translationalist method for a book that we put out called U.S. Law for Civil Lawyers. This challenge that I have in Germany of trying to make sense of what we common law lawyers think the law is to the civil law world. And in this book called U.S. Law for Civil Lawyers, which is for legal practice, on every page, all of the terms of art, we translate them into German, French, Spanish, and Italian at the bottom of the page. This is the idea then of how translationalism works. You have to be able to work forward and backward in that regard. So translationalism teaches us two things then. We learn foreign law very differently when we learn our own law and laws in text. Okay, so that is my technical presentation. Then we can leave this for discussion this afternoon, part 4 here. So thank you very much for your attention. I hope this gives you some ideas of what I see as being what we call the technical way in which then we have to work on this. We only talked a little bit about the environmental part of it, but that really is the subcategory. The first part here is about legal education itself more generally and how that has changed. So thank you once again, and I think we return to
Thank you so much, sir, for taking us to the environmental journey of different countries, for making us think how to compare, why to compare, the concepts like functionalism, translationalism. These are all important, and how learning one's own legal system and how learning different foreign legal system is altogether different. I believe that students and the participants have gained a lot of wisdom on this topic. Thank you, sir. Now, I would like to request Dr. M.K. Ramesh, sir, to kindly address the gathering.
I was just wondering that the presentation made by Professor
Yes, sir.
may evoke some response, observations, critiques, comments, and even suggestions, and even doubts to get it clarified from him. So, if it is agreeable to both the dean and all of you, and if Professor Kirk would agree, we will have an interaction between you and them on all that you presented, so that it will take it to a different level of learning. Because just like 2020 cricket, the points are made, and for a shortage of time that he was able to just present it, but the response he has not been able to get. I think there has to be some participation.
It's
And
like-
for that, if it's agreeable, we will have his interactions. And after the tea break, I can take over.
Sure.
Instead of that 1 hour interaction where we will be passive listeners, let it be interacting now. Be able to.
Like sir has very rightly said that if there are any doubts and if students want to ask something to the sir related to the topic that he has covered, they are most welcome. You can raise your hands and we'll pass over the mic to you.
I must say that it's an amazing lecture which requires one full day workshop on each of the slides that he presented. So I think we will be doing injustice if you don't interact with him. This is your opportunity. Please go ahead.
So yes,
So we can have the mic. We can have the.
Namaste to the gathering. Just an observation. I have taught environmental law for a couple of years, and the perspective that I had today is totally opposite to what is there in the practice. It's more of, let's say, we focus more on the law than the legislative part. So I was noting down the point that teaching environmental law with more inspiration and less information. No doubt, we here the inspiration in the sense I did not get what the inspiration is to follow the law or to get self motivated to spread the awareness, but in practicality or in fact, what's happening is it's more an information but less of inspiration. And the next point that I want to say, can statutory, so legal culture can be understood by a statutory text. The question is, can we get to know about the legal culture by statutory text? And the next observation is, litigation part, you say that focus on a litigation, not on a legislation. But practitioners would have more idea about the litigation, but the academicians as such doesn't know much about the litigation. Is the practical difficulty that I have observed. And you speak about more of comparative law compared to the other. And in the syllabus, we have one unit wherein international environment law. The other rest legislation, there is no such comparative required by the teacher or to be taught. And thus there is maybe as a blown up syllabus we can bring in comparative study, but as such there is no much scope or say encouragement to go ahead with comparison in each unit. If we study Indian law, that is sufficient, and if you know the Indian law, that is sufficient to present the matter in the Indian courts. So you need not know the other country law. And necessity makes you work, and when there is not much necessity, then you are not encouraged or motivated to work. That is the another observation. Thank you.
Okay. I should have been writing. Let me just start with the first point that you made. I would never suggest that a successful lawyer doesn't first need to know what the statute says. Of course, but I think that in the past we would have regarded that as being the beginning and the end of what the lawyer needs to know. And I think that today we regard that as being just a given. And it's something that, like any other information, where in the past it could have required a big research program to get the information, now it's a few clicks on the laptop and you've got it there. And you can get the commentary, and you can get the dissenting opinion, and you can get it all very easily. So yes, of course, it still needs to be known, but the bigger challenge of the 21st century is that it's just the beginning. So yes, it needs to be known, but it's just the beginning. The last point that you made, I think that's why we're having our workshop, is that I think comparative law is something that needs to be introduced into curricula as something essential, as a method. For the reason I said, it's not just because you're going to go somewhere else and practice. It's because we are by nature, we use comparativism as a way of understanding the world already. It makes us better lawyers at home, and it does give us more options to give to our clients. So I think there are real reasons for it. You mentioned international law, international environmental law. International law has an extremely important role to play, but we have to keep in mind that international law is the law very often among states, and I think that most of our students are not going to be representing states. And so insofar as they're not going to be representing states, I think it's helpful to give them something with which to work that they can actually go and practice law. And now I think is the most important point that you made. Why is it not sufficient to be an Indian lawyer to study Indian law? And that's what I want to go do if I say I'm a lawyer in that regard. That's where the inspiration part comes in. The inspiration is to inspire the students who want to know more about the law and to fill in the checklist. I think that when I speak to people sometimes who are not law students, not law professors, have nothing to do with law, they use the word framework all the time. My natural science colleagues, they're always talking about legal frameworks. And so I tease them, I say, well, if there's a legal framework, what's inside the framework? And they look at me and say, well, you used the word, I didn't. If you're going to call law the framework, what's on the inside? And they don't quite have an answer for it. But in their mind, law is just a framework. Somehow it just provides the limits of what you're not allowed to do. I think our students sometimes come to law thinking that's what it is. It's a list of rules of what you can and can't do as well. So the inspiration part that I'm talking about there is to inspire them to look for opportunities. I like to use the example that when MC Mehta brought his action before the Supreme Court and said that, look, the Indian Constitution requires all Indians to be responsible for the environment, but it doesn't give us any tools by which to be responsible for the environment. The court answered and said, well, okay, if we accept your argument, what should we do? And he said, cinemas, radio programs all have to have environmental programming in them, and there must be environmental textbooks and environmental education in every school and in every second and third level in India. He didn't look at the Constitution as a framework. He didn't look at the Constitution of India as a limitation, a set of rules. He looked at it as an opportunity to challenge it and go ask for something further. To say that if we are going to have the responsibility to do this, we must have the tools, and the court can give us the opportunity to have those tools. And now there is required environmental study for every level in India. That was a very creative way of looking at law by MC Mehta that I don't think a law student thinks law is a checklist we have. That's where I think the inspiration part is needed. Does that make sense? Does that help answer your question? Thank you. Yes.
Hello. Good afternoon, sir. So I am Aslan Zaidi from US Law College, a student of law. So I just have a simple question stating that India has a combination of both civil and common law, rather than saying it's just common law, and rather saying it's not, it doesn't follow any aspects of civil law. So when that is a question, we see that in Indian perspective, majority of the aspects are covered by civil law. Only the loopholes or the gaps are filled by the common law in the Indian perspective. Whether it can be aspects of Animal Welfare Board versus A. Nagaraja, or the aspects of MC Mehta case. And all those cases are seen with regards to both the combinations. Is it not correct to say that law should be viewed with a combination of both aspects rather than saying just a interested linear movement of just one side? What is your opinion on that, sir?
Thank you for that question. Let me see. I admitted something that you asked, and I can answer your question by going back to what she said, if I find it here. Okay, you asked, to add to your question, you asked whether legal culture can be taught from a text. We're trying. This is a textbook that I've written called Legal Culture in the United States for exactly that purpose, for people who want to understand U.S. law, but not understand it as just a list of statutes to be memorized, of how that culture works. So the way the book is constructed is first to understand how comparativism works, because anybody who wants to understand legal culture in the United States from the outside is necessarily a comparativist. We have to be clear about that. Once one does that, then you look at the tools by which you do it, and only then you look at the objects of analysis. The tools by which we do it, I call cultural reference frames. So as you look at the objects, you're putting on these eyeglasses to look at the objects of study. You're looking at institutions like courts, prisons, police officers, forest officers, whatever the case may be. But we have all these cultural things that come into play: sociology, history, language, disciplinarity, and philosophy. So if you can't go there and observe, which most people can't do, then this is about the best that can be done. So yes, I think it can be done to a useful degree. It's not as perfect as if we all had the opportunity to just fly around the world and visit other legal systems all the time to see how they work, but I think it can be done. And this connects with your question insofar as, despite the fact that you might say in India that you have civil law elements to the law. In 2 weeks ago in Delhi, when I gave a series of lectures, and today, every time I make a reference to some legal difference, and I just look at the faces in the audience, that's why I say I'm happy to be among the common law family. I call this the spirit of the common law. There may be elements of the civil law, but I'm telling you that this is a common law culture, even if there are elements of the civil law to it. If you look at the 55 states of Africa, none of them are pure civil or common law systems. They're all mixed systems, many of which have returned in post-colonial times to pre-colonial legal systems. So they've got local legal systems that they put together with their French colonial or English colonial system and put something together as well. So if you look just to those forms, we're really putting together a vegetable salad there. Yes, we're putting several things together. But when we ask, what is the overall feel? And on this book that I'm showing you here, the person who reviewed it on the back, he wrote a very nice thing, Professor Lawrence Solon of Brooklyn Law School in New York. He said, the most important thing about this book is that it gives the reader the opportunity to understand what it feels like to be an American lawyer. This is what legal culture should be able to give us a sense of. And my sense, I'm not an Indian lawyer, but my sense is the practice of law in India feels like common law. I don't think it feels like civil law. And we can talk more about how civil law feels like civil law than later, if you'd like. And it feels much differently in that regard. So it's important, of course, to see where the tradition from which the elements come, but the overall feel of the practice. I mean, when I go to the courts, or I go to the High Court, or the NGT, I see practices that you would never see in continental Europe, but you would see in the United Kingdom. I was just at the Old Bailey a couple of months ago to watch criminal trials there in London, and that looks like Ireland or the United States or the High Court here. And then I go to a court in Germany, and I say, when does the trial begin? And they say, it's already begun. This seems like a series of administrative meetings. It's a very different feel. Does that help answer your question?
Very good afternoon. So my question is specifically with regards to carbon credits, because we spoke about carbon footprints as such. And with respect to carbon credits is a new system which is introduced recently. So when we say, like, when we're studying environmental law, we might have aspect of emerging trends in environmental law. But emerging trends for a professor would be different. Or like when the professor is imparting emerging trends, they would maybe skip out on topics which are very new. So how do we bring out on topics which are emerging, or like list out topics like this? For me, maybe carbon credits is an emerging topic. For others, it's not. So is there a forum or any like such platform where we can put out these are the things which can be included in curriculum so that everybody is aware of it? And could you throw some light about carbon credits as such, where it falls under even agreements also? Carbon credit agreements are happening, carbon credit taxing are happening, and it's also transnational in boundaries now. It's just not in India. So India has a lot of green space, so a lot of farmers are doing tie-ups, and these credits are being like for like 21 period, like there are so many systems for assessing these credits. So these are again going out to majorly to UK and US. So could you please throw some light on that?
Yes, I'd be happy to. Thank you. First of all, I think as a teaching question, you asked about new topics. I remember when people first started having smartphones in the classroom, and I was always sure they were just texting each other and shopping online or whatever the case was. And then I began to realize, no, they're checking to see if what I say is accurate. That's frightening, because you don't have the opportunity then to say something that you're not quite sure about, or say it in a direction that you would like it to go to, but it has to be exactly what they're going to find on the phone while they sit there checking what you are saying. That's part of this new world in which we live as environmental law teachers, is that we can be fact-checked in real time, constantly. So what do we do about that? One of the things that we do is, in the old days, our job was to have the settled knowledge and deliver it. And we waited until the knowledge was settled before we delivered it. So when it wasn't settled yet, we didn't deliver it. We can't wait for that now, because the student's going to check on the smartphone sitting there. So I think the answer to that question is that we say these are introduced as new areas of law. As I said earlier, the one that I'm working on right now, lurking, is to look on how people are doing green, so-called green investment. France has made it criminal, by the way. Greenwashing in France is criminal. And the penalty for greenwashing in France is how much money did you make off of your greenwashing campaign? You can give that to the state. Thanks very much. So this is the answer on that. Now, on the carbon credit specifically, Europe has the carbon border adjustment mechanism right now, which I think is the best example that we can talk about. India's unhappy about it. Brazil's unhappy about it. The United States is unhappy about it. Everybody's unhappy about it except for Europe. I am unconvinced carbon credits are effective. What the carbon border adjustment mechanism will do is it will prevent leakage in carbon accounting. And it will mean that if the United States wants to produce products using dirtier methods than Europe does and sell them to Europe, it will have to pay extra to sell those products in Europe, which should act as an incentive to make them cleaner in the United States to begin with, which is what everybody hopes the goal is. But something that we've all been sort of hiding behind in international trade with carbon for years is that insofar as Europe likes to claim it's clean, it's because China does all of its manufacturing now. And so if it's really a one world system, the idea of suggesting Europe is clean but China is not, well, you would have to make that a complete system, then Europe should only be using products made in Europe. And you see how quickly that system comes to a close. When carbon credits were invented, and they were actually, the idea was first invented for sulfur, it was invented in the United States, it worked. But that's because we worked out ways of getting non-sulfur or low-sulfur fuels on the market quickly. We haven't come up with some way of doing that with carbon. Has anybody here ever been to the Conference of the Parties for the UNFCCC? If you go to that conference, there are upwards of 30 to 40,000 people going to it. Estimates are about 3,000 delegates, maybe another 7,000 with NGOs that are active. Who are the other 20 to 30,000 people there? Some of them are carbon traders. So when I go, I purposely go to the carbon traders building. They get their own building at the Conference of the Parties. They're the best dressed. They're the best looking men and women who are there. They could be selling cars, cigarettes, or carbon credits. They don't care. They're selling something. This is what I believe carbon credits have added to the world, is another industry where people have another product to buy and sell called the carbon credit. But if we ask the question, can we, with cause and effect certainty, show that there's been a reduction in overall carbon emissions because carbon credits exist? I'm not convinced. Does that answer your question?
Very good afternoon, sir. My name is Sanjay Bhavka. I have a very hypothetical question for you. As I teach jurisprudence, the question contains some philosophical elements. So I'll pitch my question. Can we inculcate the spirit of environmentalism in people like we have done with the nationalism? If can, how? Also, in what ways academicians of law play a role in this model, sir?
Thank you for your question.
Thank you.
I think this is actually one for Professor Ramesh. He'll answer this after the tea break. Law in a pluralist society can be used as the basis to give people the idea for action or for developing a program. I'm convinced of that. If you have an homogeneous society, then law probably doesn't have as much of that role. Let's say you had a society in which we had one religion. I can't think of the culture in the world that it does. But let's say the Italians, I think they're all Catholics. Okay, the Italians are all Catholics. So if they want to move the population, they get the Catholic Church to say or do something, and the population takes on that sort of position. But if you have different ethnic backgrounds, different languages, different religions, law, in that sense, since the invention of the state 350 years ago, law can actually, yes, it can provide that sort of across the board, agreed upon basis from which to take action. So if law can do so, why not environmental law? So I think the answer to your question is yes, it can do so. Environmentalism can be that thing. Environmental law can be the thing that causes environmentalism to actually have that sort of movement, that sort of traction. Okay? Professor Ramesh will answer the rest of your question after the tea.
Good afternoon, Professor. Myself, Narendra from University Law College. So my question is pertaining to deforestation in India. Deforestation, we have various laws and policies in India to govern deforestation. But still, how far this effective implementation of this deforestation laws in India? We come across various cases, still deforestation is happening. So why the laws or policies are not effective to control deforestation in India?
Ooh, okay. This one I don't think I can answer. One thing I can answer for you on a general basis, though, is why is any environmental statute, let's say forests, it could be anything, why is the statute once written in a way that presumably is going to fix the problem, doesn't fix the problem? Why is it not implemented? That is a legal cultural question. Why is the statute not being implemented? Non-implementation, I would suggest to you, and we can go back here. Much further back than I thought it was. This is to me the reason why implementation does not happen. If it's in somebody's economic interest for it not to happen. And if it's in somebody's economic interest for it not to happen, then they will spend billions on lobbying for it not to happen, because the politicians can make the law, or they'll spend billions in advertising for it not to be implemented once the law has been made in that regard. I think we would be, again, I'll use the word naive, to believe that states are more powerful than private interests. I think this was probably an idea that was true in the 1970s still. If we look at that, when environmental law in many states of the world began to be called environmental law, and statutes were passed called environmental statutes, and constitutions added environmental provisions, because prior to that there was private law. We live next to each other. You have a farm, I have a farm. You have animals on your farm. I say that you have ruined the groundwater, now I can't grow vegetables because of that. Today we call that an environmental issue. In the past we would say, I take an action against you to replace my water, you ruined my water. That was when it was just me. Now you're Monsanto. The reason the state had to get involved when we made environmental law public law instead of private law is we said the little individual can't take on Monsanto. We need the state to take on Monsanto. So we invented public environmental law, and we gave all the powers to the state when we make environmental statutes, thinking that the state was an even power over and against private interests. In the 1970s, that was probably true. But since then, we've got these corporations like Microsoft that are as big, they have a bigger income than 32 of the 55 countries of Africa. We have to come to terms with that. This sort of corporate power is not something that when we invented public law in 1972 for environment that we had anticipated. And so now we're still acting as though the state is a bigger force or a bigger power and can implement the law, and it's no longer the case. I think that's generally the case. Whether that's true for forests in India.
That is the penultimate question of the session. We'll have it later. This is the second last question.
Good morning, Professor. My name is Apurva, and my question is actually a very rudimentary one. We as youngsters, law students, how do we contribute towards this environmental renaissance or the environmental revolution? Thank you.
How do we, sorry,
Contribute as youngsters?
Yeah, thank you for the question. One of the programs that I manage in Cologne is called the International Master of Environmental Sciences. It's interdisciplinary. So we get people from every discipline possible. We have 5 in the university, 6 faculties teaching. So it's social sciences, law, medicine, natural sciences, and the philosophy faculty all contribute to this. And very often I have students who have come from another country and another discipline, especially for the natural sciences. I still remember my first assistant was a chemist from Cameroon. And he came to me and he said, I know chemistry, but I want to do something. this was exactly the sense that you were expressing right now. He said, I don't want to just be a bottle washer for somebody else for the rest of my career. How do I take the knowledge that I'm learning at the university and actually do something with it? One of the things that I think is very good with Indian legal education is you do have these extern programs between semesters where you are getting in contact with practice. So this is where you learn how to practice. I had a colleague one time who made the analogy to medicine. He said, you know, we graduate people from law school who, if they walked into a courtroom, might not know where to stand. He said, by comparison, could you imagine if a medical faculty graduated someone who came upon a car accident and could administer first aid? It's a bit frightening, isn't it? It's kind of true, though. So one of the first things is, what people have to learn is simply within law itself, whether it's environmental, tax, commercial, family, I don't care what it is, how do I actually practice this? What do I do to do it? And that's why you have these opportunities with externships that I think are very useful for doing that. And that should feed, that's why it's very good that it's interspersed with the semesters, that you go back to the classroom and say, you know, when I was on the externship, I was thinking about this, I had this problem. Now I need to know, what was the actual thinking behind it, the theory that I could apply to it. So that's one of the things. The second is, I think that the idea of the large law firm, it has unjustifiably overtaken the practice of law. I don't think that everybody who trains to be a lawyer needs to think that the only way I can earn a living is to go join a big law firm. You can come out of legal education, not necessarily as an individual, although there are courageous people who do. They just begin the practice of law on their own. I hope they have family to support them for a few years first. But a few friends can get together, a few lawyers already in practice can take on another lawyer if you want to do something. Now, if law is just a way to go make money, then join the big law firm and just be a little piece in the big wheel and wear the nice suit of clothes and people will make money. And it'll probably take quite a while before you learn how to do something, but you can do that. So to me, the thing to do is to do as much as possible, as soon as possible. While someone is a law student, through externing, but it's upon finishing law school, you should say, I want to be a practicing lawyer. I don't want to be an employee of a very large fill in the blank. And then look for the opportunities that allow you to do that. If somebody wants to go make money, that's their business. They can go make money, but I don't see people learning to practice law with any money.
I'll take the last question. Professor, more of formal learning or more of formal education about your own legal system and culture makes us less disposed towards learning the foreign legal culture. Now, this is a issue I think which needs to be taken care of. So, as right after reading something which is not of my country, of my legal system, my comparative brain creeps in. And like if I read a certain law from US for now, my Indian understanding will kick in, which is 18, 19 years of just living in the system and 5, 6 years of formal education in the law. How do I unlearn that part or at least keep it aside to actually gain a first person understanding, or at least as you put it, to feel like an American law student for that time?
Okay, thank you. I don't think the goal is to unlearn it. You can't. That'd be a mistake. It's to bring it to consciousness. And this is where, since we're going to have our tea right now as well. The important thing is to know where you stand. I like to use this example when I'm teaching myself. I show people this. It's called MacArthur's Universal Corrective Map of the World. And the first thing I ask people is, what's wrong with this map? Upside down, right? Based upon what?
Not
Based on how we see it.
Based upon how you see it. Is it based upon the material objects of nature? No. If you were out in the space station looking at Earth, Is there an up and down, a north and a south? No, there's not. The Earth has a rotation, but aside from that, when you're out in space, it doesn't have anything else. All the rest of that are learned cultural interpretations of how the world actually is supposed to be viewed. So MacArthur's an Australian. Gee, he made a map that puts Australia on the top and in the middle. And he did this on purpose to illustrate exactly that point. You don't need to, so unlearning, you can't and you shouldn't have the goal to not want to be a German lawyer, an Indian lawyer, whatever the case is. But bring to consciousness, what does that do to your understanding? Where do you stand when you make your observation of Bangladeshi law, Canadian law, Korean law? Not, I want to be a Bangladeshi lawyer, Canadian lawyer, Korean lawyer, but what am I conscious of? How am I seeing the world in that regard? As I said to you earlier, I'm constantly catching myself when my German colleagues make some reference to how law works, obviously. I think, well, that's not only not obvious, I think it's a bit strange. And I think, I'm not allowed to say that. It's not strange for them. This is normal for them. But I have to realize where I'm standing when I make that. But that is tremendously educational for yourself. And every day of my teaching life, when I become conscious of where I'm standing, when I make the observation of someone else's culture, I learn something. So knowing what it feels like is very difficult in that regard, but it doesn't mean you have to unlearn your own.
Thank you, sir, and thank you, participants, for such a wonderful interactive session. Now let's disperse for tea. Tea is served already, and we'll commence another session after 15 minutes. The outsiders, people not belonging to the university or the college, can use the washroom facility on third floor and fourth floor.
हम सारे आर्ट ले सकते हैं
You're pushing.
You're sitting in you should know where you are, what you are. You're sitting as if you're sitting in your house. Powerful point. Powerful point. No more formalities, I can start straight away. Because the dean has warned that no more than half an hour for me.
No.
And after that's reassuring for everyone because
Yes.
lunch is close by. And, I feel it will be a total dilution if I take you further in the discussion on what we started in the morning. Thanks to Professor Garg Anka, for such a kind of a template that is given for learning environmental law and uh, bringing in the comparative environmental law into the entire discourse of learning of the subject. But since the dean has given a mandate that you occupy for half an hour, and since there has also been a promise that I made in the inaugural session itself that I will do a little bit of an experiment, but so as to be very much within the context, let me start off with a couple of things. No PowerPoint with me because I have prepared a dozen slides for comparative law session. I thought that it would be a 1.5 hour lecture session and in which I have discussions along with Professor Kirk, who would have another session. And then when I saw the program schedule, I just set it aside and Professor Mallikarjun asked me, why don't you give some new insights into learning of environmental law? I said there are no new insights. Insights are already there. You can pick a few of them and then put it together for the consideration of the teachers who are going to take it forward. So anyway, let me start with a couple of observations made by you in your interaction with Professor Kirk. One is an observation made by one of you, I think, a student from the University Law College. I think I made a note of it, yeah. The distinction into common law and civil law. See, there's a problem in both the packaging and branding. It suits the legal systems if you can pigeonhole a legal system under one head or the other. If you are not in the common law system, you are in the civil law system, and it's very natural. For us, as having been ruled by the empire that never, whose sun will never set, that colonial legacy made us a common law country. And so we have accepted that we are a common law country. Yes, predominantly much of what we have as law, what we have as the legal system, and even our law learning and education and research is very much molded in the common law tradition. Very true. But not known to many of us that we have also absorbed, and thanks to the makers of our Indian Constitution, that we have not only absorbed the common law tradition and the dense influence in crafting the document of faith of a new nation, but we also have brought in the civil law elements into the making of the fundamental law of the land. And so naturally, we are not an out and out common law country. And we also have certain slices of the ideas that has populated the civil law system. And in addition to this, India is both a combination of both common law and civil law, plus much more. He was referring to the cultures. The legal culture is very, very, very unique. The Indian legal culture. Somebody was asking about teaching jurisprudence and how do we bring in those values in the teaching of environmental law. I need one full session on that. I won't take much time on that. But certainly, these values and traditions, consciously or unconsciously, have also gotten into the law that we have crafted. Much of what we have in the wildlife law is the Endangered Species Act in a different avatar of the American into the Indian law. But go a little deeper into it. Certainly, after the amendments that have come to the Wildlife Protection Act, you do see that many of those ideas of sacred groves that we had, part of our tradition, many of the ideas with regard to the concern for conservation and protection of life and life forms, an integral aspect of our tradition, finds expression in this body of law. So that way there is something very Indian about this. Only thing is we have not been able to really pick that and present it in the classroom. I think it's something very interesting for us as teachers of environmental law to bring in those elements as well. Nationalism. We talk of internationalism. We talk of commons, the global commons and common concern of humanity. Well, these are very much integrated in our Vedic literature. 2 weeks from now, I am just going to have a lecture in the BORI. Have you heard of this? Bhandarkar Oriental Research Institute, Pune, which is one of the treasure houses of all our ancient learning, not just in law, in every aspect of it. And they wanted to bring in a little bit of ancient Indian wisdom in environmental law. And for that, they want a lecture series by me, and I'm going to do that. And if you just make a little effort, you would be able to find that and easily be able to relate it to the statutory law that we have. And I think we need to do that. As teachers, we have to get closer to the soil from which we come. And that's possible only when we make a little effort, a little bit of an exercise before we get into the classroom. Or even as you get into the classroom, well, questions of the kind that you posed, it makes the teacher to think on his feet as he did. Look at that MacArthur map that he presented before you. Such a delightful thing, I tell you. How do you look at your worldview? What's the kind of worldview that you would have? Don't pigeonhole the Indian legal system as just in the environmental law sphere as a command and control system. No, I don't agree with this for the simple reason that yes, it's command and control to a large extent, but at the same time you have several other models woven into it. You want participatory element in it, you have it in that. You want joint governance aspect of it, it is there in environmental law. And this is another problem that we have. When you talk of environmental law, when you speak about that, and I was in the company of about 150 environmental law teachers, hardcore environmental law teachers in the American societies, American Bar Association's annual event of environmental law teachers, in which I had a couple of sessions on environmental law from the Indian side. The predominant thinking is environmental law means it is pollution control, waste management, impact assessment, period. That's the end of it. And right from the time when we started learning environmental law, I don't say teaching environmental law, here in our law school, we broke that barrier. Environmental law cannot be purely a brown law. It has green elements in it as well. And these two are together. Nature does not live in such compartments. And you're talking of environment, right? And if that is so, you need to really respond to that rhythm of nature in your law discourse as well. Otherwise, you are divorcing law learning from life. And so that way, I would rather put it that yes, we have predominance of the common law, both in law practice and in the pedagogy that we have. But we should not lose sight of those roots from which we come. And those roots have, some of them, by the law of desuetude, have either shrunken or disappeared from our perception and thinking. But
there are still some which are living law. And if you would like to know more about that, about our living traditions of resource conservation management, please read the 2 volumes published by Center for Science and Environment, Dying Wisdom, just on water conservation and management. Beautiful volumes. All those good traditions that we had, which can rival the best of modern techniques and traditions in water resource management, not just rival, better than that, are very much there. And even to this day, I don't know how many of you know about that. When it comes to water management system, and I learned that in some of the Western universities, they use the Humpy as a model. Have you heard of Humpy?
Yes.
You all know about it. The water management system of Humpy was supposed to be one of the most advanced ones of that time, which we did not really recognize, and some Western scholar needed to really find it out and then educate us, and we needed to know we had that kind of a nugget in our practice. Okay, let me just take 3-4 points and then, just like the 2020 cricket, I flag them and leave it at that, so that it's an appeal to the team of law here and our CEERA team to really work together to use his slides as the template to have a 2 or 3 day workshop wherein we will really do that workshop where you will be doing the work on this template and making presentations, and then we all sit together as to see how well environmental law teaching, research and practice, and what a student, as she was mentioning about, can do about environment could be worked out. Okay, so let me flag them. One, see, when you bring in this common law and civil law tradition into the learning of environmental law, what was suggested by him as a kind of a model for learning it, do you think it is new? It cannot be new. What do you do in teaching EIA law? Will you just stick to the statutory frame and then you are done with it? Then you are doing injustice to the subject. You of course look into the genesis of this idea of EIA. You look to the principle of precaution, the German origin of it. Then you try to bring in what the Americans did about the impact assessment thing, as to how the darter snail was saved in the construction of a dam, and then you trace the evolution of the development of this law and how much of it finds expression in Indian law. Unconsciously, you're doing a bit of a comparison. But I think it has to go a little bit more in an organized way. It is not just about comparing the statutory prescription of one system with another. That's one part of it. As he was rightly mentioning about, how do you make it work and how it has worked or not worked? What are the points of similarity? What are the points of difference, deviations, aberrations, and learnings? That together would constitute our learning of comparative environmental law, like any other law. This is something that we need to really keep in mind. It is not just about EIA. It can be biodiversity law. Amazing literature is available on that subject. And in how many of the institutions you teach biodiversity law? I can tell you for sure. I have done a little bit of a study of the curriculum of different universities. It's really a challenge. For the information of Professor Kirk, let me mention that Bangalore University has such a wonderful curriculum, wherein they have put in everything concerning environment, including urban development. And in just one course, single course which you offer in a semester, you are teaching everything. So obviously you are highlighting major aspects of it and leaving out the details for the students to learn by themselves. With the result that there's no real learning of that. And the pedagogy is essentially more of textbookish rather than drawing from real life experiences. And hardly there's anything like a skill building because we are preparing the future professionals to practice. That I think we should keep in mind. And how does it help me in my profession as I begin my career? You were learning of environmental law. How does this learning of environmental law would help me to become a good practitioner of law? Can I become an environmental law professional? Is it paying? That kind of a thing that would occupy the mind of a student of law. I think we need to cater to that demand. And it's not just a demand, it's one of those mandatory requirements that we have as the one who is engaged in preparing the future professionals. So that way, it is not just textbookish, but at the same time, the ability to see the scope and the opportunity for adding to the skills or sharpening the skills of advocacy that a student of law can have. Let me just give you a simple example. Many a time, most of the time rather, in the courts of law, when you have environmental litigations come, and including an NGT, it is invariably an NGO who take it up, more as a human rights issue. Human rights issues are there, but that is not the issue when it comes to environment. And that's what you need to really keep in mind. And if you really get into that kind of a mold, then it would neither do justice to human rights nor to the environment. The underlying thing about the environmental law pedagogy is about equity, human and environmental, a combination of the two. Something I would definitely encourage every one of you to read this wonderful piece, written I think some 25 or 30 years back, 25 years back. A political scientist writes this, Environment of Justice. That's the title of the work, Environment of Justice. Have you heard of this name, David Harvey?
Yes.
Please read that. And that would give you an idea as to how, from the anthropocentric approach in understanding environmental law to an ecocentric approach to an approach which is a combination of these two, anchor to equity for both, should be the underlying theme and the signature tune of learning and teaching environmental law for a teacher like me and you. Otherwise, it would be just like any other program, as he was very passionate. When you put across, please go back to the slides again. I see so many insights in each one of the presentation aspects of presentation that he made. Referring to climate change, he was referring to a handful of corporate giants being engaged in the fouling of our atmosphere. And what do we bring into our discourse in law on the subject? Hardly much. He is very right. Of course, he did not use this expression, but let me venture to use this expression, that all this climate talk is just hot air, nothing more than that. In fact, way back in 2014-15, when Government of India asked me to advise them as to what should be the India stand, believe me, right from the current secretaries of state
the Joint Secretary, and those who are engaged in preparing the brief for India were saying there is nothing much that you can do. You can just consolidate all the positions that have been already put. There is already something called as the Durban platform, for which the entire blueprint has been prepared for the Paris Agreement. There is no elbow space for India at all. In fact, we were cornered, and as we can explain in greater detail, we hardly have anything to do about that. Please do that. I was really upset for the simple reason that when you have an opportunity of breaking fresh ground, why do you really get into that kind of a staid and very rigid positions that these states have taken? Can we really redraw the lines? They said, no, no way. As luck would have it, I had a meeting with the minister, and the minister said that whatever you give, make a copy of that and send it to me. I assure you that not only what you have given will be taken by me, I will ensure that both me and the Prime Minister would present it in the Paris Agreement, in the negotiations there. The entire idea of climate justice that took shape from there has become a mainstay now. Of course, there are so many deviations in it, so many aberrations in it that has happened since then. That's the problem with all these COPs, the Conference of Parties. But then, you as an academic, how you can contribute to widening the horizons of learning and through that make a policy intervention, the possibility of it is illimitable for the simple reason the entire body of law, which goes by the description of environmental law, both at the international level and the domestic level, is a very loosely knit body of law, more of an inspiration than something which, in very concrete terms, could be put together as the thing to be adhered to, observed, and practiced. And I think we as teachers should take advantage of it. You need to really go to the basic idea as to how do you ensure that the human being is not apart from nature, but part of nature. And for that, how do you really lay down the roadmap, the legal roadmap, and the skills that are required for that? I think the pedagogy should have to present that roadmap, that foundation for the same. The third thing, I'm very much tempted with going back to what was occurred. That would actually make you really think more seriously and at a deeper level of what he presented. There's something about the common law approach and the civil law approach. The contract thing about which he mentioned. Damages to specific action. What about Indian environmental law? Is it only damages and no specific performance? I tell you, it is there. Both of them are there. Where you apply the polluter pays principle, yes, damages. And when you have to apply precaution, specific performance. Right from the environmental policy document that you have of 2005, which came much, much later than the law. Not in a sequential way, as you know that when you have a gut feeling that here is a problem as a society, you think of a policy and then a law and then an institution of enforcement and then think of actual implementation. Please believe it or not, in a couple of pieces of material that I have produced, I have shown how so many reversals have occurred in the making of a law in India, that many a time a whim, a fiat of the Prime Minister is considered to be far more important than lex scriptum and brought into application. You need an example. the law concerning coastal zones. We did not have a law on that, but there was a diktat coming from the Prime Minister at that time. And every chief secretary was the name in a state, especially the coastal states. They took so much of pains in operationalizing it, and CRZ came much, much later, 1 decade hence. So the law comes much, much later, after an executive action, which had far more greater effect, and CRZ has been a slow starter and many a time a non-starter, even to this day, 3 decades after this law is made. You also have instances like the Environment Protection Act coming, and 2 decades later, the environment policy making its appearance very stealthily into our Indian legal system. Anyway, that's not the brief that they've asked me to reflect upon. But the point I just would like to refer to is the damages and the specific performance part. In the pollution control regime, you have by and large damages predominating the legal prescription and application. But you turn towards the natural resource management law, forest, wildlife, biodiversity, when there is nothing to replace, when it's a cul-de-sac or a point of no return, there is no question of you being allowed to go ahead to carry on a particular kind of an activity. You have to specifically adhere to the prescription that has been laid for that purpose, and you cannot do any wrong in that. And if you are on the wrong, well, that may end up it, no more business for you. You cannot carry on that activity. So no amount of money would compensate a species that is lost or a variety that's gone forever, has become extinct. So that way you apply both these principles, but these are all tools that are made available. These are all the inspirations that you have, which have gotten into the making of the law and its working. And when you look into their working, you will find that, yes, there are common law elements in it, you have civil law elements in it, but both of them have been woven into such a kind of a fabric. And it's for the lawyer, as a teacher, as a practitioner of law, as a judge, to see how well that is being put into application to ensure that environmental justice or environmental equity in the whole scheme of things. I'm tempted to get into that experiment that I said that I would do. I think I can do it in 5 minutes. I'll just take 5 minutes. It's already 1:30 and I'm real time constraint. I put 5 points and I'm still in the third point. Let me skip all that. Why I want to do an experiment in environmental law teaching as to come closer to teaching of contract law. This is certainly student focused. Let's just get into the mindset of a student. Of course, there are some students here, I don't have to get into your mindset. If I'm wrong, correct me. I, as a student of law, I just would like to see each of these courses, how they're related to each other, number one. And second, is it necessary for my practice? This is my first requirement. And to cater to that demand, I needed to really redesign, rework both the content and the methodology of teaching of environmental law to come closer to at least some of the courses. And I tell you, you name every course in law that's being taught in every institution in India or abroad, you can relate it to environmental law. Many a time, in fact, I had a wonderful cartoon with me, I would have shown it if I had the time, that many a time people would think that this fellow behaves normally all the time, but when it comes to environment, he is in a fool's paradise. So be it. They say about the lover and the lunatic and the poet thinking alike. I think teachers are also to be in that particular category. It's better to be in that rather than being out of it. Let's let's be ambitious and let's think on those lines. How do you really appeal the environmental law teaching for somebody who has already studied contract law? You have one doctrine of unjust enrichment.
Yes.
You all know it.
Yes.
I don't have to explain it to you. And in simple terms, it only means that when you get into any kind of a contractual relationship, any kind of a bargain, it should be such that whatever you get out of it, either the parties should not be of such a value and level as would put the other person at a disadvantage in an unequal bargaining position. And if you do so knowingly, then you are guilty of unjust enrichment. So common man's language. I have not used any legal jargons here. Because many a time people say that when you lawyers talk, you talk legalese and not English. So let me try to get down to the common man's level. So it should be equal bargaining power. Things are in the open. You decide for yourself and then get into that arrangement. The resources and the knowledges associated with them. As we know, as under international law, is supposed to be an adjunct to the sovereignty of the nation. Every independent nation has complete sovereignty over all the resources that are there in it. There was a concern, and that concern led to the crafting of this CBD. And what was that concern? That the resources are yours. The knowledges, the traditions and practices associated with that in conserving, protecting, maintaining, managing and improving that resource is all yours because you have complete sovereign authority over them. But there is a kind of a piracy that is occurring in that regard. And we need to contain, control and eliminate that. And for that, we need a legal device. The knowledges that you have, the practices that you have, which are nurtured and developed and then brought in an evolutionary way, new varieties of plants and animals, new solutions for the old problems that you had, medicines. Some or the other unknown to you, somebody comes here, taps that, pays you some tips, and then takes it away from you. And there is an unconscionable offense committed by him of unjustly enriching himself because he transforms this into a product, gets into the market, and makes a lot of money out of it to your disadvantage and detriment. So there has to be some kind of a level playing field whereby whatever benefits he derives, that needed to be shared so that equity would be done. And one of the pillars of this Convention on Biodiversity stands on this particular foundation. So contractual foundation, access and sharing of benefits that you derive out of the commercial application of not just the resource, but the knowledges associated with that. Contract is about private arrangement, no? It's private arrangement. And the local community. And we have a tradition of nurturing and developing a particular knowledge system which has done wonders to the people, the Ayurveda system, just as an example. Somebody gets into an arrangement with us, and this arrangement
has been worked out in such a way, the terms are such that it's to his advantage, to my disadvantage. Okay, privately work it out, get a lawyer to work it out for you. No, that way it's not possible. Why? For the simple reason that we are dealing with something, not just a resource, but the practice and knowledge, which has two elements in it: the private right, the collective right, and the national sovereign right. All the three are fused into this very idea of biodiversity. Yeah, it's a local community. No, let them negotiate. You set some guidelines to the local community to negotiate. Well, the problem is the level of understanding, the ability to negotiate, the economic condition, the social condition, or whatever, are such that they stand to lose, however intelligent that they are, and it needs the best next friend to help him, enable, empower, and make him capable to get it an arrangement. And in contract law, when you think of minor's contract, what do? You get a best friend. You get the next friend who will be able to negotiate on your behalf for your good. And who is the next friend here? It can be state. It has to be state, not can be. Why state? Because the state has a dual function. It is supposed to take care of, maintain, manage, and improve the quality of environment, the constitutional command. It has to allow for access, use, manage, and put into application the resources in an equitous way. Who says that? The directive principles of state policy in the Constitution. So what is exactly the role of the state here? The state has the dual capacity of having an obligation to act in public interest, for public welfare, for public good. On all those resources which are public in nature, including communitarian in nature, and for that it has to follow, adhere to the public trust doctrine. And like a parent, it is having the position of parents patriae. I don't have to explain, you know it. So the combination of these two functions of state would make the state negotiate on your behalf. Please read the Biodiversity Act. It's just contract. On behalf of you, the local community, there is a set of recommendations made by whom? The Biodiversity Management Committee at the local level. And if it is a resource that is there within a particular state, and the one who is going to put it into commercial application is an Indian, then that particular state, the State Biodiversity Board, would negotiate on your behalf and work out the benefit sharing mechanism. On what terms? The expression you use on mutually agreed terms, isn't it? Look at the language used in the Biodiversity Act. That's what you do in a contract, no? On mutually agreed terms only, you come to an understanding. That's how the offer and acceptance is made. But this is a different kind of a contract. What is that kind of a contract? Standard form contract. Oh, you know it. What is standard form contract? What is standard about that? Well, the terms of negotiations are already laid down. You go to the rules. And in the rules, it has been mentioned very clearly what are the modes and methods and approaches of sharing of benefits that you needed to work out. It's there in the rules of 2004. And you have a separate notification coming in the year 2014, which actually even fixes the percentage of sharing. Then what is this mutually agreed terms?
within that format. You can agree the mode, method. How do you pick any one of these methods? Or can you improve upon it as to show that it's a combination of 2, 3 of these? So to that extent, the capacity of the industry is limited, standard form. And who would enforce the standard? Of course, the state. Parent patriarchs. What is the share of the state in it? Hardly anything, 5%. 95% goes to the state, and out of this 95%, 75% goes to the local community. And this 20% and 5% is administrative cost. That's all. So the real beneficiary, the benefit claimer, gets everything here. There is equity in this. Contract, a contractual arrangement which stands by prevention of unjust enrichment. You need an illustrative example with the law. I'm just giving you one example. There was the temptation of relating environmental law to jurisprudence. You can do that. You have to wait till the workshop. If our proposal is accepted by the dean and also the law school to work upon it in greater detail and depth. I think I have taken more time than what I should have. But the essential idea behind this workshop, if I feel I have the liberty of saying that, is essentially to help we as teachers to reinvent ourselves. To really learn that this learning or teaching of environmental law is not something which is a mechanical, pedestrian exercise that one would get into. It's the most delightful one because it's a spiritual experience. You feel it. I'm feeling it every moment of it. When I start thinking about each aspect of it. But it is not just spiritualism, but rooted in ground realities has to be of value and use for the future practitioner of law. For a judge to adjudicate, you know that for the first 2 decades of the clutch of environmental laws that we made between 1970, early 1970s to early 1990s, those 2 decades, how many of these legislations and how many of these regulations became a subject matter of interpretation in the court of law? Hardly any. Most of the time it was PIL, public interest litigation, and you had the constitutional shield of a writ jurisdiction, collective communitarian right and things like that, the national interest, and so the court of law would protect our derivative right to life called as right to environment. No judge worth the name, no advocate worth the name did really reflect upon any of these provisions of law. And even to this day, believe me, reference to statutory provisions is just more ornamental, just for optics in the court of law. They invariably anchor it to the constitutional law or to those environmental principles, those half a dozen principles you have. Judges also have gotten into this kind of a mode. I think there is a need to really reorient this kind of a thinking that comes closer to civil law. To see in the statutory frame itself how these can get new meaning and expression. Don't you believe that we as lawyers, we only can interpret law and nobody else can, because we are trained in that art. And as specialists, we only can interpret the law. And environmental law presents such a glorious opportunity of interpreting the law as to anchor every prescription of law to those basic principles. And the language of environmental legal regulations are so loosely knit, it gives you excellent opportunity for interpretation. Make use of it both in the classroom and in the place where you work as a practitioner when you get into that. So this is how I see we need to get into that. Comparative law. I'm not even touching on that. He has done everything. He's a great humbler. It humbles you to know that given this kind of a problem situation, how certain other legal systems have been able to respond and how they have been able to really find solutions. That's a great learn. You also learn that how somebody messed things up, and that becomes a lesson for you not to repeat that here. Comparative law is that. You find certain things very common. When you do the comparison, make a checklist, a laundry list of those things that are very common. You pick any law concerning environment in any legal system, you have a set of principles. Those objectives are incorporated in those, and these principles are there as it is in India, elsewhere as well. But the way they find expression in law may be slightly different. So that way you have so many things in common, principles are the same. And when you get into the making of these laws based upon international conventions, even the format is the same. Maybe that in the system, and that's where you're doing the comparison, in the system where you practice civil law or you adhere to that, you have handpicked those people to enforce these laws who are experts in that field. Here also we have a provision for the same. In fact, we want to keep these institutions autonomous, not to succumb to political interference or even be subjected to the supervision authority of anybody else. When I use that expression single law, I really meant this. That in terms of conception, you are very clear that you want to create autonomous institutions, independent of any influence, including that of your other governmental institutions. But believe me, the system of law that works here, although it is supposed to be autonomous, the Pollution Control Board, for example, follows exactly the civil law, essence of that civil law of being a subset of administrative law. Have you ever seen the pollution control authorities questioning the administrative actions of the general administration? Hardly any. There are exceptions. I can give you a number of them. And every time this exception happened, the general administration comes in very powerfully, lobbies so very well as to subjugate whatever little iota of independence that this particular autonomous body has and political appointments to these top positions have really marred the very objective with which the laws are made. A study was made by us, I think sometime in 1998 or 99, 25 years back, just to get a profile of the chairman of the pollution control boards of different states. Amazing learning for us. In hardly about half a dozen of them, you really found experts in that field to head these organizations. In half of these bodies, you had Indian administrative service officers donning the mantle. And of course, in the rest of it, the political lackeys of the people in power. How do you really expect it to lead us in governance in that. Much later, Center for Science and Environment, sometime in 2006 or so, came up with another profile, which perfectly agreed with whatever we had done and more elaborate and more detailed than that. In fact, empirical study is something that we had to really engage in. And this is one example. He was actually referring to that as a practitioner of law. I think he is a real treasure house of learning on that for young lawyers to really get those tips as to how do you really get into this learning of this body of law. And this is one. A little bit of an empirical research will really give you a different kind of a light in the learning of this particular subject. But not just learning, but to highlight where the deviations have occurred and what corrections that you can come up with. Well, that's what we as academics need to do. And who knows, sometime the policymaker and lawmaker may turn upon you and ask you to advise them, and you can give the advice. And these young lawyers who are trained by you may be able to guide and help them. It has happened in India. Young law practitioners, I just did not know. Some of those practitioners of law who were our students, they said that sometime back you had said something about public trust doctrine. And I said, it's not mine. It's the MC Mehta case of 1996. I just used, no, you improvised upon it and then gave some new dimensions to it. And I was an article clerk with this particular judge who took up this 2G spectrum case. And I just gave the notes of my classroom to him, and that became part of the judgment. And your day is made. As an academic, what would you expect? Of course, no judgment acknowledge the source. No intellectual property about environmental law. I do believe in that. So that way, you are very happy that a little bit of whatever you pass on, it's not your own, it's actually borrowed from so many sources, but you have been able to put it out in a particular way, in your own way. And each of us have our own style of teaching. You continue with that, but try to adopt some of these ideas so as to enrich the quality of our learning of law. Thank you. Special thanks to Professor Mallikarjun for introducing me to such a delightful scholar. I think we all need to give a round of applause for having been introduced to this wonderful gentleman. Thank you.
Thank you so much, sir, for the valuable inputs. Now the room is open for discussion.
You're not tired. I think yeah, past the lunch time. 5 minutes. 10 minutes? Okay, 10 minutes, yeah. I have no problem because I am fully fit. I had a brunch at home before coming here. I am fully prepared. I know that you are all starving. Take your time, but not more than 10 minutes. And the question need have to be very specific. My suggestion is stick to the template given by him, or some ideas which, if I had given, stick to that. Not out of syllabus. This is the syllabus. Okay, go ahead.
Indeed, there are few observations regarding contract and environmental law. So can social contract concept and the unwritten contract concept can be brought here? Is the first question. The second question is.
Hold on. Before you proceed further, don't ask can. You need to explore as to how you can. I feel yes, you can.
Yes.
But don't ask me how I can. You have to find it out and then make a presentation when we have a workshop later.
And
Because you are my colleague, no? Had it been a student, I would have given an answer. And since you are a colleague, I think you have same, it's a shared responsibility between us.
And the second observation is.
Please, observations are welcome, not
Yes,
questions.
We call this environment law as a contract of bailment. How we can call it as a contract of bailment means, so we get the property or the natural resources from.
Hold on. I have an answer for that, but let me put it this way. When I say that environment law can be related to every discipline of law, I did not expect either myself or you
to stretch it to such an extent as to say that it conforms to every aspect of that other law. There are certain of those contractual elements in it. Well, about bailment, I don't answer that question, but I'll give you the principle. You use your imagination and relate. Have you heard of this principle of intergenerational equity?
I was saying the same sort of thing.
You have to answer that. Any other? So I take it as an observation, no question.
Sir, this question is for this question is for sir.
All right.
Sorry?
This question is
Oh,
for
yeah.
Professor.
Yes.
We'll answer together. That's okay.
Sir, you were comparing US and German law and showed why there are differences between the two countries to approach a contract. You also gave example of Ethiopia for establishing how the legal culture is preferred, payment and law. Now, if we take example of US, being a monist country and even though heavily influenced by UK law, does believe on text rather than context. So, is it right to take legal culture as a parameter in countries like US also?
It is. I don't think I make the distinction of civil law and common law as being a text or a non-text one. But I could, or perhaps I should. The United States has as much interpretation happening in the courts as the UK does, if not more. And one of the colleagues was just discussing with me before we went to tea about so-called activist judges in India and whether there's just too much taking over the legislative role by judges. What I find is if the system is healthy, the judge has the opportunity to make the interpretation that he or she feels is necessary. And people then use the label activist just means it was the outcome I didn't want. I don't think it's necessarily that the judge was being more activist than any other judge would have been on the case. It's that the person who didn't get the outcome knows that the category to appeal to that says that was a bad idea is to say that was activism and you're not supposed to do that. Does that answer your question?
You had time for one more question. No more? Tanmay, yet to prove. A colleague like you asking a question.
So, no, this is something
It's to him, no?
No, sir, it's for everyone actually. This is not very much related to environment law, but this is something which is very much related to teaching because teaching is something which is very fundamentally coming here. As Principal Sir was telling about the teaching techniques specifically. I mean, in this era where we are behind this outcome-based education system, the Bloom's taxonomy, the program outcomes, where outcome becomes very much important in teaching. So in this regard, I just want to ask you one question. Me as a teacher, I always felt this difficulty while going into the classrooms and taking up the topics. The difficulty is like where exactly the responsibility lies when it comes to accommodate such practical aspects of law into teaching. Is it the responsibility of BOS while making the curriculum itself, they accommodate such topics into the curriculum which mandates professors to do that? Or is it at the level of professor where he has a curriculum, without this also he can go to the classroom and deliver on his own through his lesson plans or whatever it may be?
Very simple answer. If the curriculum setter comes up with all the methodology, technique and everything, what you and me as teachers have got to do other than become clerks. And how does it really boil down to practical application? I think everything that we really discuss and deliberate in the classroom need have to resonate with reality and real life. Otherwise, it will be just pontification, a peroration of a Matadipati in Pravachan. That should, sorry, I'm using Sanskrit expressions here. It actually means it's just like a discourse by a guru, and which may really elevate you to ethereal level, but never the ground reality. I think we should be rooted to reality. And everything that we speak of should be something which is doable. So don't put the onus on the paper setter, the curriculum maker. It is you. You are the one who is in charge. And you are in partnership with your students here. And in a classroom of 60 and 80, young, bright minds, man, the way they are going to really think about what we are going to say actually lights you up. The classroom becomes a prayer hall where you get such insights if you are able to lead them to. Like you, I have same difficulty. You say that oftentimes I have this difficulty. I say that I have difficulty every day when I get to the class. Because the students are engaged in so many other activities. To pay attention to the class itself is very tough.
Yes.
I agree with you. and we share the same thing. And let me share one experience, and you must have had many. One experience is my students in the law school. I don't think that they're very disciplined. They're perhaps more indisciplined than others are. Quite rightly also, because we may not make things interesting for them. They were preparing for that annual gala or something. The very next day, the preparation ought to start. So naturally, their interest was on something else other than what they should learn from me in the classroom. And I had come prepared to the classroom to discuss that wonderful case law, T.M. Godavaram Tirumalpad versus Union of India, which has redefined administration. Yeah, part of administration. Huh? What do? As I get into the classroom, I am already cautioned by the class representative. Sir, the students want to take things easy. I said, I want to take things easiest. Don't worry. I sat with them and told them, I have a problem. Please solve it and then you can go. So at that moment itself, I reconstructed the entire case and presented it as though that somebody had come to me for advice. And if you help me, I will get you a cup of tea or something like that. Or I will ask a mentor to help you out on that. Believe me, the next 2 hours was such intensive interaction. The students were really giving a new light to whatever little learning the judges had given in the Godavarman case. It happens. You feel that you are totally unprepared, but students prepare you to the class. and don't underestimate their ability. And don't you ever think that the students are not interested. They're interested only when you are able to really make them feel interested in what you do. And with the next election with the student body.
So actually the thing
You
is,
know the technique.
yeah, the thing is like just to give a small instance, I was teaching biotechnology law. A day comes where I have to give them a small information on what is carbon footprint, basically. So I actually, when at the end of the class, I looked at my watch. It was already 1 hour gone. So I had only 45 hours in which I have to cover my curriculum, and something which was not listed in the curriculum, I had spent 1 hour.
See, I don't think that you should get into this idea of a banking concept. That this is the information bank that I have to share it with my students. Well, very early in my career, this is what I learned, that you cannot teach everything that you should. You cannot. Because 45 hours or 60 hours or whatever, it depends upon how you are able to really make use of the talent that's available in the class. And why don't you have a small panel in the classroom itself, be in partnership with them, and then tell them that why don't you do a little bit of a research on this carbon blueprints and come prepared, make a couple of minutes presentation in my next class. Perhaps their learning is far more deeper than ours.
I will respond to it.
You will learn. I've done it several times. Yeah, you will.
It's good. Thank you.
Thank you.
This is well, I have a response to this question. I got the question right. Onus of deciding what to be taught or what we must make them learn is on the BOS, should be on the BOS. How the same has to be taught or learned, the burden is on the curriculum committee. I think we must settle down to this. And the third one, very important, very important too. I have spoken about Bloom's taxonomy, what you make them learn, it should be understood, analyzed. They should go to the level of creating something new out of what they have. Then it should seep into their mind. It should become their personality, and then they must be able to apply practically. That is, you must touch upon psychomotor domain. This is what I keep arguing every time. You cannot be satisfied with achieving one domain goal. Anything that you make children learn, it must ultimately result in accomplishment of cognitive domain goals, affective domain goals, and the psychomotor domain goals. That being the onerous task, straight answer to the question, how do we answer this difficulty, is be the mechanic in the workshop. All teachers have to be the mechanic in the workshop. That is the way to accomplish this difficult task. The task is difficult but not impossible. Onerous, true, but you yourself know it well. Quite enjoyable. The task is quite enjoyable. These are my responses to your question.
Thank you, sir. Thank you, everyone. So we have come to the conclusion of the session. I request Mr. Tarpesh Patel, Assistant Professor, KD Law College. Okay. Now I request all the guests to kindly come to the stage.
You know what he said? Now the candidates are before you, I'm going to give us marks.
Only respect, sir.
Have you passed? Exactly. I'm a 100% pass.
So with flying colors. So now we have come to the conclusion of the session. I request Mr. Tanmay J. Patel, Assistant Professor, KD Law College, to deliver the vote of thanks.
Good afternoon to all. Thanking is such a prayer that cannot be seen or touched. It must be felt by heart. I feel honored and privileged to get this opportunity to propose vote of thanks on this special occasion. As we all know, that saying thanks is a respectful way to show appreciation towards a person, but these words would be less for today's chief guest. I, on behalf of KD Law College, Bengaluru and organizing committee, convey deep regards and hearty thanks to the chief guest for the day, Professor Dr. Kirk Anker, for the festive feast of knowledge you served us today, sir. So thank you very much. I request Dr. Manoj Kumar V. Hiremat, sir, as a mark of love, affection, respect, and gratitude to present a memento. My sincere thanks to Professor Dr. M.K. Ramesh for adding to this festive feast with mouth-watering desserts. That was indeed a valuable contribution and a meaningful end for this beautiful workshop. Sir, thank you very much. I request Dr. Vishnu Prasad, sir, as a mark of love, affection, respect, and gratitude, to present them with a memento. My special thanks to Professor Dr. Sairam Bhatt, sir, in his absence, who have been the backbone of this workshop. This workshop is his brainchild. Thank you very much, sir, for introducing us to this wonderful stratum of knowledge. I am very thankful to our beloved principal, sir, Professor Dr. J. M. Mallikarjunaya, for his constant support and guidance. Thank you very much, sir. I extend my thanks to our Vice Principal, Dr. Anita MJ Madam, IQAC Coordinator, Dr. Manoj Kumar V. Hiremat, Program Coordinators, Organizing Committee members. Thank you very much. last but not the least, if time is money, then today all of you have spent millions with us. I thank all the participant friends for being part of this workshop and making it a grand success. Thank you very much. I invite all the participants to join us with lunch, which is arranged in the basement canteen. Thank you very much.
I also thank Team CEERA and faculty members from other law colleges and the PG students of University Law College, Bengaluru. Kindly join us for lunch in the basement canteen. Thank you.
Sir.